else you want to, other than introduction? You can welcome.
See, we welcome all of you to our study group meeting. I also welcome the speaker, Mr. Madhav Kanoria. A formal introduction by Hemant Mehta. Online attendee, please restrict your question to last half an hour, 20 minutes. Is my request. Unless it is a burning question or on that same topic, but then don't ask nesting questions and don't discuss case specific. With these few words, I request Hemant Mehta to introduce the speaker.
Yeah. So, good afternoon, friends. We have with us Advocate Madhav Kanoria. He is a partner in Cryil, Amarchand, Mangaldas, and he is looking after banking and finance, insolvency and bankruptcy division of Cryil, Amarchand, Mangaldas. Apart from regular this thing, he has done his BA LLB from National Law College of Bangalore, and is a member of Bar Council of Maharashtra. Madhav Kanoria is a partner in Cryil Amarchand, as I said. He is currently as a part of the firm's financing bankruptcy practice and specialize in corporate insolvency and banking related litigation, and regularly advise various stakeholders in insolvency proceedings. He has also worked in the firm's debt capital market practice, where he was frequently advising issues and bank on their domestic and international bond offerings. He joined the firm in 2010 as an associate, and after completing BA with LLB from National Law College, Bangalore. With this short introduction, I introduce Mr. Madhav and request him to start his presentation.
Yeah. Thank you, sir. Am I audible?
Yeah.
To the
Online audience also.
online
Yes,
audience.
Yes, sir.
So, given today's topic and the relevance of today's topic, because it's in fact in IBC, it is one of the most evolving areas. Sale of a corporate debtor is a going concern, even sale of business is a going concern. What we have done is we have made a short presentation, just highlighting some of the points and issues which are being contemplated in an experience from resolved cases. We have been lucky to be involved in a couple of them, Quality Limited and Gujarat Foils. So we know some intricacies of how these things work. There have been about 6 or 7 cases which have been resolved as going concern under liquidation. So we can just start the presentation. So you can move on. So it's basically liquidation and sale of a corporate debtor as a going concern during liquidation actually are two very, very contrary concepts. Because liquidation under law, under any regime, be it the company, erstwhile Companies Act regime, winding up regime, or any other regime in any other country, is a last resort. As has been upheld by numerous judgments of the Supreme Court, both under Companies Act and under the IBC, that liquidation is akin to the corporate death of the company. That after that, nothing is left, and that's why under the code also liquidation is followed by dissolution. So under the scheme of the code, it's a linear process. The first step is corporate insolvency resolution process, where the RP invites resolution plans. Now that is also insolvency resolution as a going concern. If CIRP fails within the stipulated timeline as extended by litigations, then liquidation follows. Now, under the scheme of the code, as well as the earlier regulations when they were enacted in 2016, what was envisaged was that once a liquidation order is passed, it will be a deemed discharge of employees. That means there will be no function of the company. The business will shut down, and there will be a sale of assets. And various modes of sale were prescribed. Only if the liquidator believes that running some business just more from, and the rationale was more from a perspective of the meeting the liquidation cost. If running some business was necessary, he could have retained certain employees or workmen, but otherwise it was a deemed discharged. Then through judicial development and even discussions and some litigations by workmen in some cases, the going concern concept, sale as a going concern, was introduced ultimately. it's very interesting that the code per se does not contemplate sale as a going concern. It was only introduced. So Gujarat NRE under the IBC regime, Gujarat NRE was the first case. Post that sale of the corporate debt as a going concern was introduced. Then the judgment of SR Steel 1, as we call it, ArcelorMittal versus Satish Kumar Gupta came in, where while discussing the scheme of the code, Justice Nariman said that liquidation is the last resort. Even during liquidation, the business of a corporate debtor can be sold as a going concern. So these words are significant because sale of the corporate debtor as a going concern and sale of business of a corporate debtor as a going concern are two very different concepts. And the debate mostly is around sale of corporate debt as a going concern during liquidation, which is actually, as has been, in fact, by some judgments also has been upheld, that it is against the code. Various expert committees have said it should be deleted from the regulations because that is not the correct implementation of the code or the regulations. We'll come to that in the later slides.
So sale of a business as a going concern means if the company has two assets
Exactly.
or two units or two separate units.
So exactly. So now taking a step back, sale of an undertaking or a business was also prevalent under the Companies Act. So there were certain judgments of the Supreme Court and various high courts where what used to happen was, mostly the companies which are undergoing liquidation were manufacturing companies, as opposed to now where there are a wide variety of companies which undergo the insolvency process. Mostly they were manufacturing companies. The labor force was heavily dependent upon them. So in those circumstances, courts had evolved a system where the liquidator could sell an undertaking or a business as a going concern. So a company may have 4 or 5 units or 2-3 lines of businesses. One business is viable, but the company as a whole is a sick unit. So one unit or undertaking could be sold as a going concern. It was formally introduced in the Companies Act based on an expert committee, the Iradi Committee report of 2000, where they said that since courts have evolved this, let us make selling of an undertaking as a going concern a power of the liquidator. So amendments were introduced. They were never brought into effect, but amendment was introduced in the Companies Act. The Companies Act 2013 also had a provision, but Companies Act 2013 was never implemented because IBC came into being, and the NCLT also was set up simultaneously when the IBC came into effect. So the provisions of Companies Act 2013 were never formally implemented. So that was a rationale. And one important thing to be noted is under the Companies Act, there was no concept of resolution process. It was straight away winding up and liquidation. So official liquidator used to take control of the assets, form the liquidation estate, and start selling the assets. And it used to be a long-drawn process. There were no timelines prescribed. Nothing was done. There were various litigations. It used to be high court governed. So it used to be challenging and with its own set of delays. And that is the reason why going concern sale of a business or undertaking during liquidation was brought about by the courts. Under IBC, on the other hand, it's a very scientific process. There is a resolution process. In fact, even IBC, and the philosophy behind that is that once a company comes into IBC, the other modes or voluntary modes of resolution have already failed. So because no creditor will take a company straight away to IBC, they will try to settle outside of IBC or outside of a court process. That has already failed, and that's why the IBC has been triggered. It's then RP takes over the company, runs the process, invites clients on a going concern basis. Even that has failed. That has not been able to yield any result, and that is why the company goes into liquidation. Now, why sale of business as a going concern is important. Now, under the scheme of IBC, you cannot have a piecemeal resolution. You have to have a holistic resolution of the corporate debtor. You can have a merger, demerger of businesses, but it cannot be that, okay, if a company has, and there are certain people here who know of this problem. A company may have a manufacturing unit as well as some real estate development, as well as some other interest in some other oil and gas or something. That company's promoter may have been interested in doing all those businesses under one entity or 2-3 entities. But some other acquirer may not be interested in acquiring that same line of business. So what they may want is that, okay, if I am into manufacturing, the manufacturing units should come to me. I am not interested in the real estate or oil and gas or any other unit or hospitality or whatever may be there. An ITC or a Indian hotels may be interested in the hospitality unit. Oil and gas player may be interested in the oil and gas unit. So that is currently not possible. In fact, there were newspaper reports, and we are aware that it may be introduced as an amendment to the code itself, that piecemeal resolution is possible. It has been tried in DHFL, although the entire company was resolved ultimately. It was also tried in the case of Videocon Group, where the RFRP contained various permutations, combinations. But it is still pending. So that piecemeal resolution, and there are some cases like when the IBC was at a nascent stage, NCLT Mumbai and Roofit Industries, and a couple of other cases have said that you cannot have a piecemeal sale. In fact, in Monet, the plan contained that the RA will sell some of the non-core assets. Even that was struck down by the NCLT, saying that you cannot sell assets. That is liquidation. You have to take over the assets. Later you do whatever, but plan cannot have that kind of thing. But Regulation 37 specifically allows now that you can have sale of assets of the corporate debtor as part of the resolution plan. So these were the challenges under resolution. That's why sale of a business. So when you come to liquidation, you have piecemeal sale, sale of assets as a parcel. You can have sale as a slum sale. And slum sale anyways, like the definition is assets, liabilities, but they say assets on a slum sale basis. They don't use the term liabilities, asset, and that's why going concern in liquidation becomes even more challenging, as we'll see later in the presentation. Or you can have business as a going concern, which was also there under the Companies Act. Now, what happens with sale of the corporate data as a going concern? You can just move to the next slide.
In one of the case,
Yeah.
Today the RP has not come. The HDL case, though all real estate, but he says that he has divided further the different project into the different parts. And he is getting a resolution where earlier for the entire lot nobody was ready, though all real estate. Now after division and making it project wise sale, he has got more number
Even
of
in my case also.
high number of plans which he got, and now the resolution has been possible because earlier nobody was there to take away the entire HDL because it has slump per plot also.
It has, correct. And in fact, that is also happening in the case of Supertech currently. And in some other cases also, NCLAT has already put that or rather introduced that thing into the jurisprudence, is that especially in the case of real estate companies, as you rightly said, that it could have, like say, for example, a company like Omkar. It has developments in the suburbs. It has development in posh areas. Some builder may not be interested in taking over the entire company because they may not be in a position to do development there, because you need a certain kind of quality there and in the suburbs, because there are different markets you're catering to. And that is why NCLAT, and the same thing was happening in Delhi, whether in the Noida belt, most of the builders or real estate companies which have gone into insolvency are developing in the Noida belt. But they were also having some other things in other parts like Gurgaon or other places. But an incoming person may not be interested in taking over the entire asset base. So that's why project-wise insolvency has been introduced. It is not there under the code. And in fact, if it is challenged, or if the observation of Justice Chandrachud in this Gujarat NRE case is to be taken to its logical conclusion, NCLT, NCLT should refrain from doing this. They should just follow what is there in the code. They should not come up with innovative solutions. That is what the Supreme Court has said, that stop coming up with innovative solutions, because you may do it on a case-specific basis because a judge feels so. It sets a precedent and it is misused in other cases. Like scheme was introduced, and then the good part and the bad part about the regulator is that they are very, very quick and to react to any judicial development. So as soon as some NCLT or NCLT will pass an order, you will see IBBI coming out with some amendments straight away. So that also creates a problem for governing the IBC. So now that is happening, and that's why, like as Mr. Navandar said, so you can have different the concept of undertaking in accounting, or when you do a business transfer agreement or a slum sale also, you can identify an undertaking in a business and transfer it to a party, which frequently happens outside of IBC in normal M&A transactions also, by way of a business transfer agreement for real estate. Like in the building here, 1 BKC, which is the builder is the entity is undergoing insolvency, but that was also transferred through a business transfer agreement to a buyer. And there are a lot of such examples present. So that is unfortunately not allowed specifically under the code. So if legally somebody were to ask that, can I do a piecemeal resolution under CIRP? Answer is no. If a court permits, NCLT exercises jurisdiction, and so you can do it. But legally, you have to resolve the company as a whole. There are various structures in which it can be done, but it has to be resolved as a whole. Liquidation, that problem is not there because you are selling the assets. You are recovering money, and the end goal of the process is make the pool, convert it into cash, distribute among the stakeholders as per section 53, and then close the company. That is the long and short of liquidation process under the code. What sale of the company as a going concern introduces is that you are selling the corporate data. Now we'll see in the presentation, and it's a raging or burning issue by several liquidators and acquirers. How will I acquire the company? Who will it, like under a plan? I have various exemptions from, say, if it's a listed company, from SEBI has given exemptions. There are income tax exemptions for carry forward losses and minimum alternate tax. There are other exemptions available for Companies Act. IBC clearly provides, if any shareholders approval is required for any action to implement a plan, that will be deemed to be given if a plan is approved. So for issuance of shares, for taking loans, for creating security, for transferring undertaking, all these require under the Companies Act approvals of shareholders. Section 180, 186, all these approvals are required, but they are deemed to be given for a plan. There is no such thing for under the liquidation process. So and because of these provisions, issuance of shares, cancellation of shares, other corporate actions which are required for a holistic takeover of the company are permitted under a plan. You can also have merger demerger, because now, although it was there earlier, but now with the amendment to the definition of a resolution plan, it is now amply clear that merger, amalgamation, demerger, or any kind of arrangement is also possible through a scheme under a plan. All those provisions are not applicable. So if you see some of the, like, I'm jumping a few slides, but some of the cases which have been resolved, like Topworth Steel, Mithun Alloys, which are detailed orders, where the kind of release which was sought is very similar to what you would see in a resolution plan, and they were granted also. But still, it was a smooth takeover in those companies. The only thing is NCLT also, because they could not have transgressed or overstepped their jurisdiction when it came to, say, tax authorities, when it came to certain licenses, when it came to certain other concessions under government schemes. If it was not harming anybody's interest or not treading into somebody's territory, they granted those reliefs. However, the moment, say, Section 79, for example, or 115 JB, clearly says that only for a plan you will have those exemptions under Income Tax Act. You don't have those exemptions, or those exemptions are not envisaged for a liquidation. So they said that, given the spirit, like I'm quoting from Mithun Alloys, Justice Rajshekhar's order, which says, looking at the intent of 31, it should be granted, but the bidder should approach the authorities and take the permission in accordance with law. So now, because they could not have given that, because the statute does not envisage that. If it's a listed company, delisting regulations or takeover code, or even preferential allotment under ICDR is applicable only for a plan under IBC as approved under Section 31. It is not applicable for liquidation. So the logical thing, as in, if you are discussing with a prospective bidder or a liquidator, we can say that if it is allowed for a plan, since liquidation is one step further, it should be allowed for liquidation. But
But
you
that should be the logical, na? Otherwise, why
correct.
the buyer will take it? Na? So,
Absolutely. But
suppose if I'm not going to get listing, I'm not going to get license.
then why will you take it?
Why I will take it? Yeah, na? The purpose is, see, purpose will be defeated, na? And it should be liberally, and the resolution is the only, that is the priority. Now, if the resolution is priority, then liquidation as a going concern is also a step in between the actual liquidation and the.
No, absolutely, sir. You are absolutely correct, and that is the reason why in Topworth and Mython and Quality was a listed company in the Gujarat Foils and in I forget the name of the company in Hyderabad. They IVRCL or one of the Nagarjuna companies, I think Nagarjuna companies, where they have permitted those exemptions.
It is NOCL, Nagarjuna Oil Construction Limited.
Nagarjuna Oil. Yes. So they have NCLT. So NCLT judges are pragmatic, but beyond a point, their hands are right. So if now in these companies, like in most of these companies, the good point was there were no objectors. It was the bidder who has filed against the liquidator. Liquidator will just update that, okay, I have done this process. He came as a bidder. I have issued the sales certificate, provisional sales certificate, final sales certificate. He has given the 10% or 25% deposit, and 90 days he has, and that is the limited submissions the liquidators have made in these cases. And NCLT will go through the provisions, will go to the thing. They will give the rationale also. Like in both Topworth and Mython, they have said that going concern, it is beneficial for the company, it is beneficial for the workmen. The bidder is going to take the companies free of encumbrances. All the liabilities are going to be extinguished. Distribution will be as of 53. All those things have been recorded, and that is how this takeover has taken place. But because the law is not clear, then you have that NCLAT judgment of January 2022, which has said that which also cannot be disputed. The position going concern means assets and liabilities. If you are taking as a going concern, you take with assets and liabilities. That is, in fact, one of the slides that it again, although as per law it is correct because there is no provision for liquidation as going concern, but it is very, very surprising that in a plan which is also resolution as a going concern, you have the clean slate principle reiterated in a number of judgments of the Supreme Court, that once an RA takes over and a plan is approved by the NCLT, you cannot have any past claims raising their head like a hydra on the corporate or the RA. All the claims die down. Ghanshyam Mishra is very clear that even the claims which have not been dealt with in the plan, but which pertain to pre-CRP period, will go away. Government entities cannot do initiate any proceedings. So now, as in, there are a lot of high court judgments coming up because all the companies which are resolved in 2018, 2019, Binani, SR Steel, are facing those difficulties now. And if you see various high courts, like be it Rajasthan High Court, Gujarat High Court, Delhi High Court, are giving those judgments now that income tax notices have to be quashed. They pertain to some 2012, 13, 14 period. Companies undergone resolutions, very short orders, but they are just, as routine, notices are being issued and they are being quashed. So that has become the thing. But for liquidation, given this judgment where assets and liabilities move together, how can you then take an argument that I have acquired the company on a clean slate basis? In fact, this judgment is unless it is set aside or some amendment is brought in, it is a death knell of liquidation as a going concern. In fact, liquidation so as I was saying, liquidation of the
CIRP regulation 39B, if you look at, even that also
39C, I think.
Yeah, C, whatever, 39C or D, whatever.
Yes.
That is about the going concern.
Going concern.
It specifically talks about, having a discussion between the RP and the COC about
assets
the
and liabilities.
assets and liabilities. So it's not about the judgment. The court itself talks
I
about.
mean, the regulation
No,
itself
so-
is not very clear.
CIRP
See,
Yeah,
not only
39C.
CRP, if you see the.
That is, as you rightly said, that his risk cannot be considered as precedent later on also. Because in this judgment, the valuation, the reserve price was asset come liability. Whereas normally when
It's only
you are selling,
assets.
it is
Only
liability.
assets.
And this is including liability. So this
The valuation is less.
valuation was, reserve price was fixed on that basis.
Correct.
And because of that, this case goes on a different mode. Otherwise, if they have taken only asset value, then whatever is collected would have been paid to the claimants and other stakeholders, and Otherwise, this will lead to a very absurd results also.
No, you are absolutely correct.
See,
Contingent liability.
actually, I was,
If there is a positive net worth in the company, will lead to an absurd result whereby the liabilities are taken over by the buyer, bidder, and then whatever is recovered will go directly to equity. So the claimants will not get money at the time of sale. They will get as and when the buyer who is taking over will get the money. But the equity holder will get straight money because it has been sold. So it will lead to a very absurd result in the company with a net worth.
actually, I was actually virtually present when this Pratibha Industries hearing was going on. The matter was that the buyer advocate was saying, I have bought the company at 150 crore approximately. And he was saying that why should I take over this 1,000 crore liability in a liquidation as a going concern? I am not supposed to, otherwise the entire commerciality is lost. But
And it doesn't even talk about.
No, but
the
anyhow-
Straight away say assets and liabilities. So it is definitely actually not having a valuation to it.
yes.
And the best
Huh?
and the best part is that
going to get
under a plan you can have a deferred payment also.
Exactly.
So
Here it is 90 days.
you have to give upfront because it's a mode of sale. And as you said, sir, that whatever be the underlying this thing, if liabilities are moving, then anyways it's a no show for anybody, because if liabilities are moving now, what kind of, and that's why Ghanshyam Mishra. So why Ghanshyam Mishra, which uh, there were about 7 or 8 cases from various resolutions clubbed together in Ghanshyam Mishra. A lot of people, what they used to do earlier was that they will not file their claim. There were various judgments, including in SR Steel, NCLAT, where they have said that if you don't file a claim and if your claim has not been dealt with under a plan, your claim survives. So strategically, a lot of, especially foreign players, what they were doing was, in EPC companies and other companies, steel companies, when they are supplying, they would not file their claim. They will initiate some arbitration. It is in abeyance in the moratorium period. Once the plan is approved, moratorium goes away. They will initiate the arbitration and they will say that you now pay the money. Tax is one aspect. Tax is being highlighted, but this was a tactic being adopted by various counterparties to the corporate debtor, and that is why Ghanshyam Mishra said that once a plan is approved, no past claims can attach upon the corporate debtor. What is happening in liquidation is, if this judgment, because the facts may be there, it's not clear from the judgment, but as Sir has said, any company which has assets and liabilities, and that is the first question which anybody will ask, and as lawyers we say that no, the principle, if clean slate is applicable for a plan, the plan's definition says a process like insolvency resolution is a going concern, the same should be available for liquidation. It's only logical.
I will just add to on this because when this judgment came, I did a lot certain research. So the bid document is what I went through.
In Vishisht.
So in that, further, if you go to the regulations 32, which talks about this seal as a going concern.
Assets and liabilities.
So there is clause 2 and clause 3. Clause 2 states that the last COC meeting, they form a group of asset and liability, which is to be taken.
What ma'am was saying.
Going concern say. And if that is not done, and still there is a going concern order, then the liquidator will pull that assets together and do. So in this case, what has been done is the liquidator has pulled that thing, assets and liabilities. Based on that, valuation was done, and based on that, a reserve price is done. Where actually, instead of getting certain liabilities which has to be paid later, all things were clubbed into one, and that is where the whole thing goes for a toss in this case.
Yeah. See that what he is referring, that is section 32A, subsection 2 and subsection 3.
Right.
So if you can read out now, for the purpose of sale under sub-regulation 1, the group of asset and liabilities are also covered there.
Yes.
What
Of the corporate debtor as identified by the committee of creditors. And if it is not done, then that subsection 3 comes into the picture.
Liquidator.
Where
they
the
can do
committee
with
of
this
the shall identify the group of asset and liability to be sold as a going concern in consultation with the consultation committee.
So here that was done, but here
Only
all the
regulation.
assets and liabilities were
Regulation.
considered, and based on that, the
Regulation.
valuation was done. And based on that, reserve price was fixed. So this is one of the odd case. Normally that this way going concern sale is basically a extension of CR.
Correct, absolutely.
Part
and,
2.
And what you are saying is correct, because there have been subsequent cases of NCLAT only. So where, so same thing, how tax or one of the other litigants who raises their head after the resolution plan or liquidation is the electricity boards. What they will do is they will disconnect the electricity or they will continue the electricity, but they will say that, okay, you have to pay, now you're taken over, 5 crores, 50 crores is left for the last 10 years, you have to pay. Otherwise, I'll disconnect. Where CIRP, there are enough cases. Even in liquidation, there is a case of the NCLAT which says that you are a stakeholder under the code. 53 is very clear. You come as a government entity or as another creditor, whatever your claim is. And based on that, you will be extinguished. So that is what they have said. So which clearly shows that past liabilities cannot fasten upon a bidder who has taken over the company as a going concern. And in that case also, it was a going concern sale. There are various NCLT judgments also. In fact, Topworth and Mithon say that you will get the assets because see, one thing is liabilities or regulations use the term assets and liabilities because that is the classical accounting definition of going concern, that assets, liabilities which are self-sustainable as a business should be transferred. That's how slum sales, any M&A, business transfer agreement takes. That's the premise of any corporate transaction. Assets and liabilities move together. The only difference is that if you take liabilities also on face value, then if there is a factory unit which is sold as a going concern and rest everything is non-realizable or whatever, and it is kept aside and sold separately, lenders will definitely or most certainly have some charge on that. If you pool the liabilities, then the entire purpose of the liquidation thing is getting defeated. Because one major thing is, unlike regulation 37, which is also discussed, unlike regulation 37 of the CRP regulations, where there are specific provisions that you can modify the security interest in a resolution plan, you can extend the maturity date, you can reduce the payment of the creditors. In liquidation, there is no such provision. So if a liability is moving, either it moves at par value or it has to be extinguished. There is no in between that if a 100 rupee loan is there, I will only take over 20 rupee loan for this asset when there is no justification for that, because there is no legal basis for that and there's no accounting basis also for that. Because if an asset is there, like a very basic fundamental principle of Transfer of Property Act, any asset moves with the liability. So, and that is to protect any encumbrancer on the asset, that if anybody transfers an asset to a third party, all the liabilities, be it statutory, be it third party liabilities, lenders liabilities, attached to the asset, and they move with the this thing even to a bona fide purchaser. So that's why buyer beware, because a buyer has to do his due diligence. Now here it is anyways, basic principle is both under plan and under liquidation is as is where is basis sale. As is where is would mean that in under previous acts or like be it SARFAESI, be it any public auction, as is where is would mean that there are various cases which say that some property tax is pending, some rent is pending, something is pending. It goes along with the property, you have to pay. But that is the difference between the as is where is under those statutes and as is where is under IBC. And now under SARFAESI also, because with IBC there are some amendments in SARFAESI where secured creditors have been rightly given the primary this thing and they can give a clean transfer.
So here asset whereas basis, I differ on the understanding is that when the asset means the title, whatever is shown as asset, any issue in the title that is given, but it does not. My understanding was that it does not get the liabilities does not get reached to it.
There are a lot of Allahabad High Court cases, Calcutta High Court cases, Madras High Court cases, one Bombay High Court case also under SARFAESI, which clearly say, and that's why I said, because in SARFAESI, what banks do, most sales are, say, a flat or an apartment unit or a bungalow will be sold.
Yes.
There'll be some NA conversion charges which has not been paid in Allahabad, that side. In Bombay, there'll be some property taxes, MCGM taxes, the society charges. People litigate saying, oh, because bank will not know what these charges are. They will just do a notice. If somebody comes and says, if they have not claimed it from the company, then it will be difficult. One principle is that income tax or excise or VAT or something relates to the business. So if you're selling an asset, those will still remain with the company. They will not move with the asset because they are the business taxes. But property tax, NA charges, society dues are asset specific. So that's why they move. So that is the as is where. So title is one aspect, any defect in the title, but liability. So as is, that's why as is where is, as is what is, as is this thing, whatever there is, basis is done so that tomorrow the buyer cannot say, oh, you did not disclose this liability to me, or this hidden charge was there. That's why I want to void the sale, because that is not possible under a enforcement scenario. So that is where the as is where is basis. Title, you are right. Title is one aspect, but the hidden charge is also there. But under IBC, that is not there. But now under liquidation as a going concern, it appears because, and as ma'am rightly had said, under 39C, also COC has to do assets liabilities. And there are very few, at least to my knowledge, there are very few cases where COC has actually done that exercise, because mostly they will say liquidation when dekhenge, ya phir plan will be approved, because they know beforehand. When our liquidators are doing, even I am not aware, at least, sale of a business as a going concern, whether it has happened, because sale of a corporate debt as a going concern has happened because people want to buy everything lock, stock, and barrel and not do a piecemeal this thing. At least people have attempted doing that, but I don't think there has been a successful consummation of a sale of a business as a going concern under IBC so far. So that's the reason, because liabilities, assets, distinguishment, nobody wants to take that exercise, undertake that exercise. And that is the reason why sale of a corporate debt as a going concern takes place. And with these developments, like liabilities moving along with the assets, because the regulations provide so, because somebody will argue, and that's what I understand the court also was saying. So they relied on the IBBI discussion paper after Gujarat NRE Coke. The IBBI discussion paper translated into the regulations, where they have taken the classical definition assets liabilities, and they have said going concern assets liabilities. That is what the COC has to decide along with the RP, or the liquidator has to decide along with the SEC. But since they have used that, now technically, if they are moving along with it, then the sale of a company as a going concern cannot just take off, because how will you distinguish the liabilities? So will you say, okay, tax liabilities will not move because they are government dues, lenders liabilities will not move, however liabilities to employees will move, liabilities to certain stakeholders, because that is, the IBC does not have that distinction amongst the various classes.
So far as I don't know about the GST, but in earlier era, whenever unit was, manufacturing unit was there, and the excise liability as well as sales tax liability was always attached with that particular unit, not the company.
Correct. No.
So now I don't know what is the position in GST. If you say as it is, where it is basis, means whatever excise duty dues or whatever sales tax was dues, it was also coming along with this particular assets.
You're absolutely correct, sir.
One more thing.
Yeah.
See, under IBC liquidation also, the lenders have a right under section 52 not to relinquish the asset. Now suppose that any financial creditor does not relinquish the asset and he tries to sell, then it will be under the surface
or whatever.
Surface Act. Then the buyer of that asset will be faced with all these liabilities. So why then the bank insists for not relinquishing the asset?
No,
they will be worse off, no, according if these provisions are.
So it depends on what kind of asset is being sold earlier. So as sir said, so there are various judgments: excise, VAT, sales tax attached to a business or
that
undertaking. It does not attach to an asset. So what banks do, like under SARFAESI, I don't think any undertaking has been sold. What banks will do is they will sell the plant machinery, they will sell the land separately, and that's why those cases, or they will sell some apartment flat or something. So that's why those liabilities don't travel. Now there are specific amendments, 29C, D, E in the SARFAESI Act, which say that when a bank or institution sells under SARFAESI, so-called clean slate also applies there. So because if the secured credit, because all these liabilities are below the secured creditor. So if a secured creditor has recovered the money through a process under SARFAESI, then all those liabilities will die down. So the reason is that banks can then sell undertakings as a going concern under SARFAESI, which was not happening because of these issues only. The hidden liabilities traveling along with the thing. So they are trying to bolster that market also, where banks can sell undertakings under SARFAESI.
Yeah, I have to what I said, to extend that. Now, relinquishment of security interest has to be done within
30 days.
Assuming that relinquishment of interest is not done in
Is
30 days.
deemed relinquished.
In 90 days, if the asset is not sold, it will go back to the liquidation estate. Okay. Now, if 30 days post that, within 60 days, surfacing auction cannot happen if they start from that day. It is only possible that before CRP, if they already got a decree, then to execute the decree, that 60 days period is enough. But if I have to start a surfacing process, then within the 60 days, I will not be able to complete that process, auction the property. And so when it goes to again the liquidation estate, the question arises that it comes back to the liquidator, but still the right security interest has not been recognized. So my understanding is that the liquidator will go for that sale of asset on behalf of the security interest holder, because it is now coming back to his liquidation estate, and then distribute it back. Once the money comes, he gives it back to them, recovers the cost what has to be taken, and give it to back. Now, this is my understanding, but I have one doubt in this understanding of mine also. That security interest holders who, when it gives that asset to me and it becomes a part of my liquidation estate, then how does his security right continues? Because my understanding was whenever whatever becomes a part of a liquidation estate, the holder of that rights loses that part, interest on that part. So how does this right continue, sir?
It doesn't continue. The security.
Yeah,
interest
once it
doesn't
is deemed to
continue.
be a
It is
liquidation
deemed
is-
a relinquishment.
No, it is not never deemed relinquishment.
It is.
No,
It
after
becomes part of the
Either it is
liquidation
liquidation estate or his estate.
Yeah,
It cannot be
so
in
the moment
between.
it becomes a part of the liquidation estate, the security interest is relinquished.
No, so there are various nuances to the question. So first step is when you file the claim, you would say whether you are relinquishing or not, or enforcing under 52. If within 30 days you do not say that you are not relinquishing, it is a deemed relinquishment after 30 days. That is as per the regulations. That is step number one. Step number two, which is not a settled legal position as to, because if going concern has 90-day period, I have to file my claim as a creditor within 30 days and say relinquishment or not. If I say I'm not relinquishing, there is no deeming provision, or at least no case law as such, which says that still the going concern, and that is a problem which is being faced by in a lot of cases. How will going concern take place if a lender has not relinquished right over a security over an asset? Because as a going concern, that asset will move, but if the lender is enforcing, then anyways it's not possible. The third thing is on the relinquishment per se. So this is a going concern aspect, but relinquishment per se. Now, if you relinquish, there are obviously the Technology Board of India and one recent judgment is there, which are both pending before the Supreme Court now. But the legal position, as has been there if you see the Bankruptcy Law Committee report, and I'm talking only about IBC, but there are Supreme Court judgments, very old 54 Madras High Court judgment, M.K. Ramchandran. There is Supreme Court ICS Sitco Leather. There are various other committee reports also, which clearly say that the security interest is a property right of a creditor that cannot be extinguished without the creditor's consent. When the creditor relinquishes to the liquidation estate, what the creditor is doing is they are just facilitating that, okay, it may be more beneficial if instead of me enforcing the asset outside the bankruptcy process, it is sold by the liquidator. It may yield more money, and the pool will become larger. But the security interest of the creditor, unless Supreme Court holds otherwise, security interest of the creditor does not get obliterated if the lender has relinquished the asset to the security estate. That is a very basic principle of law, not only in India, but across the world, where either you enforce or you relinquish. In both the cases, your ranking. So because now I'll take an example. What may happen? There is institution A, which has done a due diligence, lent money to a company, taken security over all the assets, plant, machinery as normal, first charge, second charge, they have taken. There is another aggressive fund player or whatever individual or some company which has given loan and taken, and we have seen these cases, taken security over a car or over a fleet of cars, 5, 6 cars. Now those cars depreciate, what is the value? But logically, if you relinquish, what will happen is total asset value with the car and the thing will be 200 crores. It will be distributed equally, but that is not what the law envisages. If you and that's based on a and the problem is arising because of the definition of relinquishment. Relinquishment in the classical sense means that you're giving up your right, but you're not. So what Technology Board of India, although they are not dealt with the thing, but what I think I understand was argued was relinquishment means that you have given up your right, so you have no rights, security interest is gone. That is not the what do you say, principle behind relinquishment under insolvency or liquidation. Relinquishment is that you're relinquishing your right of enforcement for the liquidation estate, but your right of security is still there. And that is not only in these judgments. If you see Insolvency Law Committee report, which is the expert committee formed by the IBBI and the Parliament, 2018 report, 2019 report, 2020 report, every time, in fact, in 2 reports, they have discussed this point because these points keep coming up in distribution because the same, see, 53 also applies in distribution. You have these debates about first charge, second charge, how the distribution will work under a plan. They have said, and they have then discussed and then concluded that it is such a basic principle of law, forget insolvency law, it's such a basic principle of law that your inter se arrangements, your security interests will remain intact under insolvency. You cannot be put in a worse of position in insolvency than you were pre-insolvency. If at all, it can only become better. Because pre-insolvency, if you have certain rights, those rights have to be honored in the insolvency process. So there were some discussions that whether we should clarify under the code that inter se arrangement should be honored, first charge, second charge should be there. But they have discussed that it is such a basic principle. If we keep clarifying all these things, then there is no point of having the code. So they have said that two judgments.
And it is to be distributed among all.
And,
that is what I was
actually
saying.
the liquidation part, it is somewhat there, but in resolution clause, suppose I have given a car loan and I have 10 lakhs 10 lakhs rupees car and 50 lakh rupee loan, and somebody else has if equal matching, then he will be worse off. I will be better off.
Exactly.
In the resolution
Amit
process,
Metallic-
that is a big problem.
The Amit Metallic judgment actually is a problem here, right? Because in CAR,
Amit Metallics is a problem. It's actually a, if you were to ask the honest opinion, it is not even a wrong judgment. It's just wrong English that they have used, because if you see the various parts of the judgment, para 21, 22, they have relied upon JP and they have said that the correct position that liquidation value has to be paid and all, and liquidation value under various I don't think there are any judgments on liquidation value, but under various reports, Insolvency Law Committee report, that corporate liquidation report of 2019, they have said that how the liquidation value has to be computed for a creditor, and it has to be basis the security interest, whether they are first charge, second charge, unsecured. So all those things have to be taken into account while computing the security interest. Amit Metallics, if you see what they have answered, and it is being interpreted in different ways in different forums, but what the question was before the NCL Supreme Court, what they have answered, it was on 30 subsection 4. 30 subsection 4, which was amended post SR NCLAT in August 2019. It basically says that a committee of creditors has the discretion to approve a plan, including the manner of distribution proposed, and they may take into account the value and priority of security under section 53. Now that section itself is clear that when you are distributing, you can take into account the value of and the priority of security. Because if Amit Metallics were to be applied, then SR, forget even JP, SR Steel 2, that is the plan approval committee of creditors versus Kumar Gupta, November 2019 judgment, that is wrong, because what was the challenge in SR Steel 2? SCB had some security over certain shares of a company which had zero value, but they are a secured creditor. State Bank of India and others were also secured creditors. They had the security over the Hazira plant and the machinery and everything and all the pipelines and everything which were laid down for that, and the captive power plant shares and everything. They had that security. What SCB was saying is that in a process, everything is pulled together. I am a secured creditor, you are a secured creditor. Let us all distribute equally. That is what was challenged in NCLT. NCLT, Ahmedabad came up with its own funda of distribution more equitable, Mr. Chaturvedi. It went to NCLAT. NCLAT applied its own logic, said 80-20, even operational creditors have to be paid something, everybody should be paid. And that's why the amendment was introduced by way of the ordinance. And that is what was clarified in Justice Nariman's judgment in November 2019, where he said that COC has to take into account the interests of all stakeholders. Although they are not a fiduciary, they are not a trustee for any stakeholder, they are also business people. They will take into account the interests of all stakeholders. But what a stakeholder is entitled to will depend on his entitlement as on insolvency commencement date. So your security value, whatever your ranking was, whatever your entitlement was, will be determined on that basis. And the classes and subclasses can be formed. So you can have financial operational creditors. Within financial creditors, you can have secured, unsecured. Within secured, you can have first ranking, second ranking, exclusive. And that is exactly what 34 provides. What 32? So this was the question in Amit Metallics, where they have answered some this thing 32B, which is for dissenting creditors. What it provides is that if somebody is voting against a plan, then in that case, they should be paid at least what they would have got in liquidation. Why? What is the rationale? The rationale is that everybody wants resolution. I am a creditor in the COC with voting power. I am not interested in this resolution. That is why I am voting against this. That means I am choosing liquidation over resolution. Now, in liquidation, I would have got as of 53. So that is the 53 which is guaranteed to that creditor. That is what the court, very logical, court provides. Now, in JP Kensington, what they have done for ICICI Bank, when they were interpreting 32B, when they said that it has to be paid in priority and in cash, it cannot be in securities. Although it is not there in the code, but it can still find some basis from the scheme of the code. What the Supreme Court said in JP Kensington, for a dissenting creditor, you cannot give him anything but cash because he is not interested in remaining attached to the company. You cannot give him any security NCD under the garb of any mechanism and make him attached to the company. You have to give him cash in priority. It doesn't say upfront, it says priority. So before the assenting can get anything, dissenting has to be paid in full. That is the logic. What they have introduced is that if you're not giving the creditor cash, then you give him the right to enforce the security. Now, where is that coming from? And then Amit Metallics, how it is wrongly being interpreted. Under 52, a creditor who decides not to relinquish to the liquidation estate can enforce his or her security outside the estate. What is the embargo? That if they recover less, then they come and stand in the queue in the waterfall at level 5. If they recover more, they have to appropriate towards them, and then they have to give the excess to the liquidator. And under the code, regulations also say liquidation cost and this thing. Under the code, they have to pay their proportionate share of the IRP cost, CIRP cost. That is the funda of 52. So what Supreme Court has said is that you either give him cash. Cash is what he would have got under 53, which is there in the code, or you give him the right to enforce security. Once because that is what he would have got. Whatever that creditor recovers is his liquidation value. So you give that. Now, Amit Metallics cites all those things, but Amit Metallics, if you see Amit, two judge bench judgment, JP Kensington has 3 judges. SR Steel is there. They have wrongly considered all those judgments, or it's, as I said, bad drafting. They have answered a question, and they have said what they have said is that 30, essentially, Amit Metallics is 30 subsection 4 is may. It says COC may take into account the value of and priority of security. but no creditor can force COC to say that no, you have to take 53 into consideration. It's COC's wisdom. We have seen cases where, in some cases, COC has gone by voting share purely because it's not making a difference, where they have classified into secured, unsecured. Unsecured, they are paid, say, some 2%, and remaining has gone with secured. Within secured, they have sometimes in more congenial COCs, they have also gone by first charge, second charge, because they are working capital lenders. There are other this thing. They know that recovery is there, so it is giving that kind of discretion to the COC. COC is not bound to follow 53. Amit Metallics answers that question, that COC is not bound to follow 53. Everybody is equal. But what it is, how the facts were, what was, because even the NCLT and entire judgments are not very clear on the point.
But in CIDCO versus ICICI Bank 2006,
first and second charge.
we discussed about pari passu.
But sometimes, many times we see in small cases, if the unsecured creditors are not taken care of properly, and if they have more than 34%, then they try to twist the arm, twist the.
Sir, Amit Metallics is being used. We have seen cases where unsecured creditors or subservient creditors are more than 66%. So, they can, with that, there is no doubt they can approve any kind of plan. They can approve any kind of distribution also under the plan. But using Amit Metallics, they are also trying to go against the dissenting creditor entitlement, because what the code does is it protects the value, that okay, if you're getting paid this, you can have no problem with the plan because you have got your liquidation value, you be happy with it and you move out. But what with Amit Metallics, what they are doing is, which is again going against the code and the other judgments of the Supreme Court, where they are trying to say that COC can decide what value is to be paid to even dissenting creditors. So in some cases, we have seen that they are trying to pay less than the liquidation value. That plan on the threshold itself will fall foul of 32. So that is a different thing. Those things are being done because of Amit Metallics.
And at times we find that the resolution are below liquidation value. So in that case, that further difficulty arises. No? So if the liquidation value is 100 and plan is approved at 85 or 80, then how can the dissenting creditor can be paid?
No, but that is so. You're right. Commercially, it may not make any sense, but that is the economic and legal rationale of all these provisions. What it says is, what Supreme Court has said in Maharashtra Seamless, that there is no compulsion that you have to let liquidation value is a reserve price. You can approve any plan which you think as a COC that this is the best plan for revival of the company, because that is the objective of the code. What it does in 32 for operational creditors and for dissenting financial creditors, that COC has been given the power, but some protection has to be given to the minority. And you have to understand that under our code, which is different from, say, the US code or UK code, where financial creditors have been given the power, because normally, say in the US, it's like a scheme where every class of creditors votes on the proposal, and that's how the proposal, because they, since every, like in a scheme of arrangement under Companies Act, every class of stakeholder votes on the thing, and that's how it becomes binding on all of them. Under IBC, only financial creditors have been given the power. So what the protection has been given is that for operational creditors, they should get minimum liquidation value or plan value if it were to be distributed as a 53. And for dissenting creditors, minimum liquidation value. Then with this principle, you approve a plan. So that is your commercial decision as a COC, that you are approving value is 100, you are approving 85. But you have to take the hit that if some person, his liquidation value is 20, you have to pay him 20. That is the rationale, because that person, by voting against the plan, is saying that I want liquidation, but you are forcing a resolution upon him. So at least you give him that liquidation value and throw him out of the equation. That is what the legal thing is.
Then we will have to work out his as per the charge, whether he's having first charge, second charge.
So that is the correct way of doing, working out as per the security interest and the ranking and value of the even value. So I may have a first charge, as Standard Chartered had in SR Seal, first exclusive charge on shares of that Mauritius company. They had, and based on that, they had given a loan of 3,000 crores to SR Steel, but that value was nothing. So I may have charge over some computer or some tables and chairs, but that value may have nothing. So one is priority. Second is, that's what 34 says, value and priority. So you look at the value, look at the priority. But what Amit Metallics people are doing is that even first charge, because normally a person having exclusive charge of first charge will be the person who will want to dissent to a plan. And what people are trying to do is that pool their asset also and give them whatever they decide. So that is what is being the problem and causing litigations in several cases.
Yeah, Prashant ji, you had certain question. Prashant Jain.
No, I'll read his question, he sent it to me.
Acha, yes, thank you.
He's saying, the speaker is saying that dissenting creditor can be paid in priority, but not upfront. So is that correct? Minimum liquidation.
So I'll give you an example. How the now after JP Kensington, how the code is structured is the priority for a plan is first is CIRP cost, second is operational creditors and workmen operational creditors, third is dissenting financial creditors, fourth is ascending financial creditors. Upfront means that on the day of implementation you do pay. It is nowhere written either in the code or the regulations or in the judgment that you have to pay upfront. What is there is priority. Now, what does priority mean? Priority means that if there are classes of payments, unless an earlier class has been paid in full, whatever they were supposed to be paid, the next class cannot be paid. This is what is called fair and equitable treatment under insolvency law as well. Fair and equitable is if a class higher than me has been paid, then I can be paid. If they have not been paid, I will not get anything. That is a basic principle, and that is a fair and equitable treatment. So, if a plan is envisaging that they are going to pay 10 crores upfront, that is upfront meaning say 90 days, 60 days, whatever, and the remaining 200 crores after 1 year. Now, that 10 crore upfront may have say 5 crores of CIRP cost, 1 crore of this operational creditors payment, assuming. So 4 crores is left. So that 4 crores has to go to the descending creditors. Assuming that out of the total plan value, descending creditors are supposed to get 50 crores and ascending are supposed to get 150 crores. So that 4 will go to descending. So ascending has not recovered anything. Descending has recovered their 4 crores out of, so 46 is left. So upfront, I don't have to pay 50 to the descending creditors. Now, when the next installment comes, since they have to be paid in priority, I have to pay them from the next installment. Now, obviously, if it's a longish thing, then somebody may argue that, oh, what is the point? I'm still stuck. But that is something which the Supreme Court will take a call at a relevant time. But right now, the law is that in the next installment, say the next installment is 6 months down the line, 30 crores. So entire 30 will go to dissenting. And
So
until he's paid in full, and then and that's the thing. And that is why if you see most plans nowadays, what the negotiation is happening is that if the voting share is distributed equitably amongst creditors, they're actually discussing to come at a solution where everybody assents to the plan. So they are giving even if security can be challenged or whatever, they are still giving credence to the security interest. They are giving credence of priority. They're saying that you would have got this much. We'll pay you 2 crores extra. We have seen this happening. So this is what and this is the actual commercial wisdom, that you have the plan approved so that everybody gets something from every installment. Otherwise, if somebody dissents, they have to be paid in full and in priority. Then assenting will get after 2 years or 1 year as per the plan, which then nobody will assent to a plan.
There will be advantage in dissenting.
Yeah. And which is also, if you use a Jyoti structure judgment of the NCLAT, which is now pending in Supreme Court, where Justice Mukhopadhyay actually said that this is not an incentive to dissent. The provision is protection, but it should not become an incentive to dissent. Now that is happening in certain cases, which anyways some litigations will take place. Some are pending also. Jyoti structure is pending in Supreme Court that is lying.
So in the Amit Matlik also this thing has been made that it cannot be incentivized for dissenting creditors. But there is also an issue in that, as you said, they are creditors, they are still understanding that the dissenting should get upfront. Not only creditors, even among IPs also, this is still being considered the upfront, dissenting means upfront. Though we have also, in our 1 or 2 plan also, we have tried to do this. But still, they try to go into the court and they try to challenge. Some of the courts are taking view positive, some are taking negative. Dissenting means everything upfront. though there was in 2019, there was a change in the regulation. The earlier regulation was saying that before getting by anyone as a syndicator, the syndicator should be paid full. But then now the new change says that it has to pay in priority. So priority, what you define is perfectly right. The word of priority. There is no definition of priority defined in any dictionary so far. Though Supreme Court can define afterwards. But how do we put in the plan, because the situation where creditors having a different type of rights, then is okay, because they understand that somebody, everyone has to get something. But if there are some majority, suppose somebody is having a 50% right, somebody is having a 20% right, the remaining guys, those who are having 5 or 10%, they become an issue in that thing. And if once you cross 66%, no issue. But if you do not cross 66%, then this become a big fight among lenders. I have faced this thing, and I have done same thing what you said, but it was challenged.
Sir, the simple thing is that if there is enough money to give upfront, see, because if you see, as I said, court doesn't use upfront. Judgment, if you scroll through that judgment of JP Kensington, the relevant paras being 82 to 140 for descending creditors, they don't use upfront anywhere. Upfront, and there is no, as you said, priority is not defined. You are right, priority is not defined, but priority is understood that priority means before. So before the next class gets, I should be paid, like how CRV cost has to be paid in priority. Upfront is something which is in fact not defined, because upfront technically means on the day of approval, but upfront has different connotation in different contexts. So there is, so I'm not sure whether any judgments are there, but upfront, if anybody were to challenge that I have to be paid upfront, even when the plan is a long-term deferred plan, and which has been approved by the COC, I have to be paid upfront. I don't think it will be sustainable in any court. And by court I mean court and not a tribunal, because
You can have primary break and have.
Code provides for priority only. If you see the code, subsection 2B, it always talks in priority.
Priority only.
See, upfront is used in a resolution plan for 30 days. Primarily, that doesn't mean that that's a choice a resolution applicant wants to pay. So,
correct.
Theoretically, if I'm not wrong, the resolution plan can also be where the entire upfront money is for reviving the factory and thereafter paying the CRP cost also. Does it? It does not say that CRP cost also has to be paid on day 0.
Absolutely. In fact, earlier it was said that CRP cost has to be paid within 30 days from plan approval. Now even that regulation has been amended. So it has to be paid in priority. So before I can pay any creditor, I have to pay CRP cost. But it doesn't say I have to pay CRP cost on day 1, day 30, day 60, or day 180. I have to pay in priority. So as for the plan which is approved, CRP cost has to be paid, and as you rightly said, even the others have to be paid accordingly. It doesn't say upfront. But anyways, like I will not put it beyond any stakeholder to interpret, because obviously it's suitable to say upfront and litigate, because we also face these litigations very routinely, that people go to court, and in fact one of the matters is pending in Supreme Court also, where they are saying that they should have been paid on as soon as the plan was approved. So CRP cost and descending creditor should have been paid on day 1 only, is what one bank is contending in Supreme Court now.
Just to take it back to
I think we restrict the question from online, otherwise it is disturbing.
In one of the matter, what has happened is, as far as this cost is concerned, CRP and liquidation cost. So CRP and liquidation cost includes liquidator fees. Now, the company had gone under the scheme, under 230. And in scheme, they have gone ahead with a repayment plan to the credit for 7 years. And that has been approved. And now the fees of the liquidator, they is being as per the
scheme.
The scheme, they have the one who has bought it. He, as per that, but liquidator has to wait till 7 years to get his fees.
And been approved by the NCLT also.
NCLT has approved, and he filed the application. It is dismissed. Now we are on the going to file for the Supreme Court against this order. So 7 years he has to wait for his fees for the scheme that has been approved in favor of third party.
But unless Supreme Court says a scheme, approved scheme, that is what the law is. He'll be paid before the creditors, but he has to wait for 7 years.
The scheme also would have been filed through liquidator. So how come the liquidator was not aware of his own interest?
No, this, in that, liquidation, is distribution of the things. You have a liquidator fee in two parts.
Huh.
One on realization, one on distribution. They are
But
saying
for
that it
scheme
will be
also, there is a
distributed
separate
at the end of 7th year. So at that time, you will get the money.
Because you can't get unless it is distributed.
distributor.
And then.
We'll see how it shapes up. This type of issues also come.
Yeah.
I think we should stick, what we are doing is, we are now going back to the resolution.
I think we should stick to the
topic.
Because there are a lot of things in sale as a going
No.
concern, probably. and you can
But
run through
but
that.
it's probably because it's very closely interlinked with resolution. What is happening in resolution?
I have a question here. See, the CIRP process, we all know that when there is a resolution plan, it is supposed to be, finally approved by the adjudicating authority, thereby the IA is filed. However, the similar thing is not envisaged in the liquidation process. So I'm failed to understand that it clearly says that you sell the assets and the mode of sale, the manner of sale under regulation 32 A to F is already given. If you adapt A to D, you actually do not go to the NCLT unless until there is a private sale or a sale to the related party, other than the parish. So why E and F, the people have to approach the adjudicating authority?
For
I think
relief.
there is-
For waiver of all the dues. For incentive, were that all
But
waivers?
does it actually adjudicating authority has a power for? Because the code or the regulation doesn't envisage to take the approval from the adjudicating authority.
No, but then how I will get waiver?
So
No,
how
suppose
the
income tax
NCLT
waiver,
does
sale tax
actually
waiver,
entertain
GST.
such things? If I'm not wrong, in one of the judgment, even NCLT has mentioned, I don't remember the judgment, but it has mentioned very categorically that why you are coming to me, because the code doesn't mention that you should take an approval from me.
For liquidation.
In liquidation.
That
In liquidation sale or going concern sale?
as a going concern.
Okay. Because in fact,
Because it says only you go for a dissolution, you file an application.
Exactly.
Right? So why all
and you
this?
file the periodic reports.
Yeah, and it's a liquidator who has a power to issue the sale certificate, right? Why
Yeah.
you go to the adjudicating authority?
So
But then as a going concern, suppose I'm a old share to be transferred.
Code or regulation doesn't talk about.
But then old
it.
shares to be cancelled, name to be continued.
I think there is a, let us.
No, I'm saying that because liquidation order is passed by NCLT and if you're trying to sell as a going concern, you have to go to NCLT for approval without that.
No, if you want any concession or something, then only you will go to the.
No, so
Why you go?
Sir is right. So there are two aspects to it. One is under the scheme of IBC for a plan. It's a very set mechanism. COC approves it. RP checks for the prima facie compliances, places before COC. COC takes a decision, approves it after looking at the feasibility viability, goes to NCLT. NCLT approves, becomes binding on all the stakeholders. That is the scheme. And very scientific that, as I was saying earlier, certain approvals are deemed to have been given. So shareholders approvals, joint venture partners, everything is deemed to have been given. For other approvals, they have given 1 year's time. That after 1 year also, so the underlying assumption is that no authority will act immediately and cancel a license because 1 year has been given. And if you ask for certain release of concessions which are beyond the NCLT's power, they will say no, please approach the authority. For a sale of a corporate data as a going concern, and in fact, if you go to the previous slide, Jayatashri, this is what this slide in fact covers, that for a plan, all the steps, so not only the approval, but steps how to implement the plan. As I was saying earlier, issuing shares, forming a board of directors, reducing the payable or settling the amounts, exemptions under income tax, exemptions from SEBI regulations, other regulations are available. So you have to go to the NCLT as per the code. For sale of a corporate as a going concern, none of these are available. In fact, there is no mechanism. It only, if you see even that sale as a going concern, I think it is used only 8 or 10 times in the liquidation regulations. It is not used in the code. In the regulations and mostly in 32 and 32A.
Yes.
That is where it is used. And I think in the closure report, now where they've introduced that closure report and this thing, it is used there. There is no prescription as to what a scheme under a sale as a going concern during liquidation has to look like. What all actions can be done. So there is no option, as Sir rightly said, but to approach the NCLT and get the relief. Now that is where the problem or the interplay between the regulations and this sale process arises, because under the liquidation regulations, RP issues, the liquidator issues an advertisement for public auction or private sale or whatever is a mode, chooses a successful bidder. If you see 32A to F are all part of the same scheme. In the sense, it's a sale, mode of sale. A, B, C, D, E, F. So there is no distinction that for E or for F or for A, you have to follow a different process, and for A, B, C, you have to follow a different process. Everything follows the same process. You come out with an advertisement, sell the company, issue a sales certificate, pay within 10 days or 15 days and 90 days. That is the thing. But since how will the liquidator hand over the company to the person? Because if you're selling an asset, you can deliver a title certificate. If you're doing a business as a going concern, you can just say that this business is transferred, this title is transferred to you, and enter it to a BTA, or you can do a slump sale. But for corporate debtor, you have to sell the shares. Now, unlike an RP replaces a board. Shareholders approval is not required. Liquidator, there is no concept of liquidator becoming a shareholder or board. Liquidator is a
Sale of a corporate debtor as a going concern, there is no question of selling the shares.
Oh,
It's
company
the
as a
shares
whole.
which
Company
get
is not sold.
dissolved and the new shares are issued to
but
the
who
new
but that's the question.
It's a liquidator
But that's the
does.
question. Who will issue that? Liquidator cannot do that. Where is the liquidator having the power to do that?
Otherwise, who will do it?
Exactly. That's why you have to go to NCLT. Liquidator
The order should be there for
liquidator is not. That's what I was saying. Liquidator is not the board of the company. For issuance of shares, you need shareholders approval because you have to, because IBC does not give you a license to deviate from any law. If there is an inconsistency, IBC prevails, but you have to follow other laws also because IBC is not in derogation of other laws. So for issuance of securities, the prescribed statute is the Companies Act. If it's a listed company, a Companies Act plus the SEBI regulations. That is a simple thing. If it is a foreign investor, then you look at FEMA regulations. That is applicable for plan also. That has to be applicable for liquidation as a going concern also. Who will issue the shares? That is a burning question because liquidator has no power to issue shares. Liquidator is not the board of the company. Liquidator is not a shareholder of the company. Liquidator is a court-appointed officer overlooking at the liquidation process. Liquidator can only transfer title to an asset because that is the power conferred upon a liquidator, not to issue shares, not to form the board, not to change the board, not to do any other actions. You don't have any, and why do you go to NCLT? You don't have any income tax exemptions. So for a plan now with the amendments to the Income Tax Act, it's very clearly set out that carry forward losses can be taken advantage of. Other things can be done under the provisions. For liquidation as a going concern, no such provisions are there. If it's a listed company like Quality, there is no delisting procedure because delisting regulations say that only if it's a plan approved under Section 31 of the IBC, you can follow this delisting procedure. Takeover, same thing. Pref issue under ICDR, same thing. Nothing for liquidation. So you cannot take these exercises without NCLT giving you an order. Even if the NCLT gives an order, it is not sure that you will be able to justify to the other regulators because things get stuck also with exchanges and all that. So for plan, it's a clear direction. There are internal circulars by SEBI to exchanges and everything is taken care of. For liquidation as a going concern, there is nothing. And that is the reason why in the initial slides, 2 expert committees, in fact, 3, if you say expert bodies, have said that liquidation of a corporate as a going concern should be deleted from the IBC. Insolvency Law Committee report of 2020 has said that. There was a principal bench judgment in the Invent Asset Reconstruction, Prakash Kumar's judgment of September 2020, which he has said that it is going against the IBC and relying on that judgment was subsequently set aside by the NCLT. But relying on that, the Standing Committee of the Parliament of Finance or the Parliament has said that this provision should be. So what they have said is continue, and even the Insolvency Law Committee report has said that continue sale of a business as a going concern. That is important. But because business can be run, some employees can be retained by the liquidator, that is envisaged under the code. There is nothing contrary between the code and the regulations and the implementing the code and the regulations. But selling the company as a going concern, when you have already failed in the process, because there is no distinction, because if you see the reliefs also which are being sought, as I said earlier, there is no distinction in a resolution plan and sale of company as a going concern. if you have failed for 330 days to get a plan, then what makes you think that you will, in the 90 days, you'll be able to succeed to sell the company as a going concern? That is what the expert bodies have said. It has not been deleted. And the regulations, because some bidders have also lobbied that if you're continuing it, at least bring about some clarity, because every time, and the problem is, given the way NCLTs function, under the regulations, you have a limited timeline of 90 days. If you don't pay within 90 days, the sale can be cancelled. Your EMD is forfeited and your advance is forfeited. So you have to pay within those 90 days. So that means that you have to, if you read the regulations and take it to the logical end, you have to get your application adjudicated within 90 days.
Yes.
If you go beyond 90 days, you will stand on you will be in a situation where you will lose your money and you will lose your right to take the company. That is what the regulations envisage. So, and given the NCLT delays and the regulations, in fact, the judgments of NCLT Ahmedabad, NCLT Bombay, which say that it has to be strictly construed in the sense that 90 days, if you don't pay, you cancel the sale, you forfeit the money, and you go ahead and do a resale, because that is how you have to do it. Otherwise, people will keep delaying the thing. So, with these in mind, that's why people have been lobbying that if you're continuing sale as a going concern, at least bring some clarity that ABC will be applicable in these cases. It will be the same as a plan. Just bring about that clarity. But that is also not there. So you are in a situation where you are doing what you have already failed in CIRP. You are doing that.
As under 230 is also given.
230 is another animal which will require another session only, because 230 is something which has actually been there in the Act, Companies Act also. It has a different thing, because 230, if you see, and under IBC, that's the thing. Even judges are grappling as to how it will work, because 230 is very clear. All stakeholders, including shareholders, have to vote on the scheme.
75%.
So it is tougher than, I think, CIRP also.
It is, and
tough.
Tougher than selling as a going concern and all.
Exactly.
As compared to CIRP, it is tough.
No, in that situation, what happened? The buyer has to pay almost 100% and then go to the NCLT.
Yeah.
Liquidation as a going concern, the Bombay Tribunal and all, it will less likely to get.
But that option is given.
Option has been given.
That this 90 days period, the order, first of all, sale as a going concern, it should be in the order of liquidation. So the liquidator, so the RP, when he is filing the liquidation application, the COC has to put it that this company should be sold in liquidation as a going concern. Based on that, the order will be issued. And if the order does not have a statement that this is to be sold as a going concern, then you cannot move ahead in selling that as a going concern. And if you still feel as a liquidator that there is a probability of maximization, then you move and the again adjudicating authority to seek his permission to sell it as going concern.
Whether it is
Once the sale as a
essential.
going concern is approved, within 90 days, he has to conclude the going concern sale. Now, in that case, there has been recent one case law where this 90 days, there was the liquidator was successful in getting one buyer who paid the EMD, but he defaulted in the future and he spent time for 120 days to pay the balance. Where the judgment is that no, you forfeit the money, but as the liquidator has tried his best to get the liquidation, so a fresh 90 days is given to you for getting another buyer. Now that means if a buyer who has agreed to pay initially and thought that he may get a continuation and extension, he loses his right and again the bidding has to be done. And in that, you get a buyer. Now that is going to be a challenging thing. So instead of that, that absurd judgment actually should have either given the extension or else it should have stopped the sale as a going
But the
concern.
previous buyer also can bid in the second.
That we don't know.
He has lost
the money. He's already lost. That's what I'm saying.
Right of 90 days, either the sale as a going concern should be withdrawn under all circumstances or not. We have a unique case at present where the liquidation order is there. Auction has been conducted. There is an auction buyer who is purchased and paid the EMD. And between that 60 days time when he has to make the balance payment, the terms has changed. So the land which was purchased by him there is some reclassification happened.
Yeah.
And some government authority, some circular has come into place. So he has objected it. Now he has filed an application that I am ready still to take over of the things. Provided this is sold to me as a green concern, because that classification effect will not happen. So there is a liquidation term, sale under liquidation term, and now the application is pending to consider as a going concern sale, and then he takes over the company, which was actually to be dissolved.
It has happened in a couple of other cases also, especially in power companies. When after thermal power, when the government this thing, people realize they had bid for the assets, but they realize that this going concern may be better because you may get the exemptions and licenses as opposed to piecemeal sale. So that is
Yes, I think.
yeah. So this is basically like since there is no, like we've already discussed, since there is no provision for like the contours of the going concern sale of the corporate data in liquidation. That's why people like bidders approach the NCLT. So under a plan, RP approaches NCLT saying that this is a process followed, this COC is approved, now you approve the thing. Here bidders approach the NCLT and say, I have bid, I have paid the money, I have to pay the money, remaining money in so and so days. I have bought the company as a going concern, but I don't know how the transfer will take place to me. So please give me this relief. So it started with Topword Tubes. Now there are some 7-8 judgments which have granted the reliefs. The detailed ones are Topword Tubes and Mithrin Alloys, where they have analyzed the reliefs and they have said this is granted, this is not granted. For this, you go to the appropriate authority. So that is how it is implemented, and that is why the necessity of approaching the NCLT to get it approved. Although it is not envisaged under the code, but you have to go to the NCLT for it to be implemented.
Sir, what happened in the case of PSL Limited? Sale as a going concern approved, bidder has paid their EMD. And what finally happened?
Sir, I'm not aware of this. There were some other issues also, no? Some ED
and some problem is there.
But
Everything is approved. Buyer fulfill their obligation. Then after that, created all this.
But sir, as in that happens in plan also. Plan like BPSL is one good example where because of ED issues in the Supreme Court, the plan implementation was delayed by a long time. Although it has now been implemented, it's been a year since it was implemented, but it was delayed because.
NCLT is approving certain delay. Say income tax carry forward is another thing. Can this department will accept it? They can challenge it.
So they can challenge it before NCLAT. So as I was saying earlier, income tax department, at least in my this thing, GST we have seen some appeals. Income tax never files any appeals in NCLAT or Supreme Court. They will issue notices, and the RA will have to approach the appropriate forum. Earlier, in the pendency of the plan, they used to approach NCLT and get it settled there. But now it is writ jurisdiction.
There is no clarity.
No.
Income tax is there. In last union budget, only the plan. Now there is one clause here that officer has to give the effect of the plan into the tax sheet. But what will happen in the case of this?
Sir, so what is happening is, as I was saying earlier, all the plans which have been implemented, like 4 years back, 2018, 2019 plans, their income tax is like the largest, defaulter, you can say from a plan perspective, that they are sending notices. And the RAs are approaching high courts and getting it quashed as a matter of routine. Given this litigation, what I understand is after the union budget, the finance minister had told CBDT and CBIC that kindly effect is one thing, but be more aware of the process. Because what happens is at the central level or at the higher level, they may be aware of IBC and everything, but practical difficulty, and several RAs have said this, that if you go into the interior areas, the tax officer is dealing or the local officer is dealing, they don't know about IBC. They will still issue the notice and initiate litigation. So that is the reason why if you see the CBIC circular, GST department circular, it's very clear that there has to be a nodal officer who has to disseminate information, and the relevant officers have to be more proactive and submit their claims and everything, and not because that will achieve two purposes. One is not entail unnecessary litigation and costs for the government also. And second thing is bring about more certainty in the process, because the same issues, every plan, same issues, because a government officer will want certainty that he has not taken a decision. Court has directed him to take a decision. That's why he is doing it. That's why NCLT was not flying with them, because they are not very this thing. But if you see, very few of them challenge before the Supreme Court. High Court's pass order, Ultratech, Binani Cement, still they are fighting. Every 6 months, you will see a Rajasthan High Court judgment where some sales tax, some VAT officer, some octroi, previous octroi, this thing, they have raised a demand, sent a notice of attachment and everything. They approach the High Court. High Court passes an order, ki what is this? And then they release the attachment. So that is still happening in Ultratech. In SR Steel, water charges were there. In BPSL, income tax notice was there. Delhi High Court has passed a judgment. So all these litigations are there. That is the reason CBDT was also supposed to come with a similar circular for its officers. They have not issued a circular yet, but it is expected that it will come out soon, because they are analyzing. What we understand is they are putting in data to see what all litigations are pending and what all can be done. Because under the Income Tax Act, you can do an assessment for previous years. They have curtailed the period, but you still can do assessment of previous years. So if it is happening after approval of plan, then what is the impact of it? Because technically, you could not have known the liabilities. Ghanshyam Mishra is there, but still they have to take a call. So that is the reason why some mechanism is being worked out that for companies under IBC, you just on a best, what we understand is best effort basis, just submit a claim and don't wait for assessment or reassessment, because that will anyways not have any impact on your overall process.
Yeah, in best effort basis claim from that. When you do a claim, you do an affidavit confirming the correctness of the claim. Then that best effort basis will
In
be checking out.
the affidavit, you can write this is on a because everybody like on interest also. For example, banks have to compute interest manually after the account becomes NPA. There are mistakes there also, because they will apply. Sometimes they will forget to apply 1 day, 31 days, 28 days. They will not take into effect. That happens. And that's why in the affidavit, if you see, they will say, this is the thing as per the records and to the best of my knowledge. So, and best effort also we have seen being put in operational creditors and financial creditors, saying that this has been computed at so and so this thing. Because in certain accounts which are NPA from 2014-13, to compute for so many years, and when the company is going into insolvency in 2019, for 5 years manually to compute, and there's no system. Like, it's surprising, but the banks have no system. They actually do it manually.
Even SBI,
Bank
SBI also has put up a claim of 750 crore. Now, after calculation error and everything, we received the final claim for 350 crore. So that is the difference.
It is very common.
Try to charge compounding interest. It was agreement. It was simple interest.
No, my point is the question that we as RPs are concerned is our duty is to collate and verify. Now, when we get this affidavit, normally at my end we check that this affidavit basically can become a base for the litigation if it is given with clarity. No, I have not come across the affidavit which says that this is on best effort. This is the claim that has put. We have at present gone on DGFT and excise. We are telling because same authority, two departments are sending the claim for the same thing, and it is making enormous number of claims. Whereas when you give something on affidavit, means that it cannot be given a wrong. It will be a contempt case there. So we are challenging them on that. Now they have come back and said we are coordinating, because it is practically impossible for a RP. If that matter is 2014, how to relate and reconcile that thing?
Correct.
Within the time, that is again 7 days from the claim receipt, we have to revert back to that. So it becomes very challenging. So here, this lacuna basically, what we use at our end do is we use the affidavit at our base. Apart from that,
fundamental is not there in case of CIRP process. That was long back. It has been corrected. Now it is a declaration.
Declaration. People don't give
Without
it.
any stamp paper, without any.
Because you are adjudicating the claim. You are not verifying. You are actually adjudicating the claim during the liquidation process. So there is no best effort basis.
And
In the
see,
liquidation,
actually,
but that
two,
can happen in the CR.
I think
But
2
there is a
months
declaration,
back,
no, but if it is something is wrong or something is claimed
हाँ, उसमें ऐसे लिखा है,
fraudulently.
to best of our
the-
knowledge,
now
declaration.
2 months, see,
there is
2
a
months
declaration
back,
also, one of
2
the-
months back, we had a meeting here with IBBI officials. So what is the government? Government is also this income tax department, GST department. They have appointed a nodal officer, and this IBBI will be sending them the list of the companies which are admitted to CRP based on our form.
That's what.
And they will be sending that respective nodal officer will be sending to
For
the
GST.
concerned GST officer, and then GST officer will be, because nowadays what was happening was that nobody was aware that the company is under insolvency. So now IBB has taken up the task of sending the information to the nodal officer every weekly or every monthly, and that nodal officer will be submitting in his department and they will be filing the claim. So now the chances of claim not being received will be minimized.
Not for income tax. Income tax is
Yeah,
also
it is still under
consideration.
It's not,
Nodal office has been already identified. They are responsible, but they are not doing.
Not doing.
GST.
Income tax. GST,
No, no,
excise, all out done. Because of that
GST
circular,
very
everyone
circular,
is
yeah.
accepting the finance ministry circular.
Income tax, they are not doing it because of the historicity of the assessment. So that's why I was saying that GST. So the ministry has told both CBDT and CBIC to come out with the guidelines. So for GST, they have appointed the nodal officers who will be coordinating with IBBI.
Everyone has
Yeah.
done. Here also nodal officer is appointed, but the other work is not being done by the nodal officer. The nodal officer is the principal commissioner.
No, it's not being done because it is an April thing. So now they are putting that is happening. They are putting the processes in place. Correct. Because what they have to do is that where the company has businesses which are GST officer or officers in charge who are assessing officers who have to be notified. So all that is taking time. CBDT has not even issued a circular to set up the nodal officer. So that is the difference. But if that is implemented, whenever it is implemented, this system, so all these tax claims and everything will hopefully become very less. The litigations which are pending because of tax claims. So
Post CR.
Post CIRP, post resolution, post implementation of the plan.
On tax.
As because as I said, modern test path, this.
The issues will increase for the RPs during CR. Because what we are facing today now with excise and all, they are after us that you act. We have sent you the claim, you accept our. That's all. No other question, no other thing, and in a day, 10 messages they send. We'll send on that.
Oh, excise
We
department,
say that
GST
now
department.
documents
Exactly,
missing,
excise,
that's
GST,
the
PF.
things issue, but
PF, so
have
they
not
come in the office.
No, you have sent, you just accept our.
Office
We are
market.
statutory authority.
Yeah,
accept
आपको
that. So RP's work will increase.
नॉर्मली आपको बुलाते हैं, अभी वो आते हैं सामने से.
दिया, कैसा दिया, क्या करें? 7Q का दिया. Yes, sir, दिया.
I think we can go
Yeah.
ahead.
Yes, sir.
So just go to the previous slide. So this is the other issue which we have anyways discussed, that this judgment which has created the questions as to whether clean slate is applicable to sale of a company as a going concern, which is applicable to a plan, which is a stated objective of liquidation also, because you buy the asset free of encumbrances once it is sold to you. But if you are doing as a going concern, technically the liabilities will still be there. So it also goes against the judgments in Topworth and others, which say that when you are buying the company, it's on a clean slate basis. And the last slide is just on the reliefs which are typically sought and why bidders have to go to NCLT. Most of them are for tax and issuance of shares and formation of board, basic corporate actions which are not envisaged where nobody has the power to undertake during liquidation. So that is the reason why it becomes necessary to approach the NCLT to get the reliefs.
So like, sometimes I go to the arbitration part of any foreign company who have not filed their claim at that time. That was also not envisaged by many cases in liquidation or CRP. So they purposefully not submitted the claim.
Correct.
Now,
So in CIRP, it is very clear if the claim filed, not filed, dealt with, not dealt with, if it relates to a pre-CIRP period. So there are only two classes of claims for a plan. One is pre-CIRP, which is closed, and one is CIRP, which is CIRP cost. So whatever is there is in these two buckets. Once you pay and implement the plan, you cannot have any liability towards the pre-CRP claims. In liquidation, it has to be better because liquidation technically means that company is being closed, but the only difference is under this. So if liabilities continue, technically all those litigations and the liability under litigation. So if you are buying the company, there's some arbitration pending by you against you for claims, counterclaims, those will continue. And if an award is passed against you, subject to challenges, you will have to pay under the award, which cannot be the intention of this provision, because you cannot have a worse off position than you would have under a plan, because of both are legally identical. Company as a going concern. So resolution of a company as a going concern, sale of a company as a going concern, they are identical provisions, but you cannot have exemptions for plan and not have for liquidation. That is the thing. So either now, if they go by the suggestions, they may either delete the clause or they may bring out some more clarity so as to ensure that it is done in a time-bound manner. Otherwise, you will now there have been cases where luckily NCLTs have passed the orders in that time period and people have been able to implement. But if cases increase where NCLT is not able to pass those orders in the 90-day period, then you will see more cases of default happening, because nobody may want to take a risk with these questions left open, that you are not able to get a carry forward losses, you are not able to get certain things without an NCLT order being there. So that is the issue for sale as a going
Then
concern.
the bidder will lose the money, na 10%, 15%, whatever he has paid, he will lose the money. So that
I would go a step further that nobody may bid, and you may see bidders, in fact, based on advertisements, going to court and seeking clarity first before bidding. That may happen if some clarity is not introduced by way of regulations.
But then by that time 90 days will be over, and then some of the assets which are prime asset may be sold. Then the liquidation as a going concern will not
this thing. Correct. So that is the thing. So you need to have either wholesale changes being introduced in the regulations or take away the provision altogether, because the current thing is left too much to the discretion of the courts and too much to the discretion of the authorities, and also creating a non-level playing field with a resolution plan, which is the problem for sale as a corporate as a going concern.
So something should be introduced in the code itself also, na?
Code or
purely regulation, again that problem will come. Na? Again the judges will say nothing, that Mohan James earlier judgment NCLT.
Mohan James invent asset reconstruction. But they have said invent asset reconstruction is a very detailed judgment where he has analyzed the provisions of the code, and Prakash Kumar, and he has said that under the code you cannot have a company surviving post liquidation. So how can you have a sale of a company as a going concern in liquidation? It is contrary to the provisions of the code. That judgment, although set aside by the NCLAT, that judgment has been taken into account by the standing committee, and they have said that this provision should be dropped from this thing because the judgment is correct.
I think Mohan James was also from Prakash Kumar, BV Prakash.
Yeah. BSc Prakash Kumar. That was a 2018 judgment.
Yes. And when it came, it was
2020 judgment.
And when Mohan James came, it was really something like terror, nothing, not to do anything further in this.
See, ultimately in the liquidation, there has to be a dissolution, right? But when you actually sell the corporate debtor as a going concern, there has to be no dissolution. It remains. So then how it can be in the liquidation?
And one concern which is being raised by this thing is that although now 29A is applicable anyways to all modes of liquidation, but like promoters also playing this thing and not letting a resolution happen and then trying to buy it at a cheap this thing in liquidation as a going concern through this thing. That is also an issue which has come up in various discussions with IBBI, that's why the sale as a going concern, liquidation as a going concern may have to be relooked at, because it may be counterproductive to the resolution process.
29A also on this liquidation as a going concern is a challenge that comes, because there is no provision there to when except that sale under auction, when you are making the participant should be 29A compliant. But when you are taking this as a going concern sale, I as a bidder of the going concern sale, I will take it over and I may be fronting the thing. So 29A compliance basically is of no use at that time.
That is a concern being raised, that it could happen that you are doing
It is happening. That is
backdoor entry. Any further questions?
We keep it questions for the open forum.
Questions for.
In case of resolution plan, we always have that, there is a liability is always by and large is higher than the asset valuation. Because the valuation is done for the asset given in the CRP process. Since we are able to able to have the successful resolution plan because there is a substantial haircut, and thereby there is a bidder who comes and things happen. But when 39C, when we read, it says the group of assets and liability. It doesn't allow you to somewhere,
do a haircut.
Into a resolution plan, a haircut. So the liability is always going to be higher than the asset. So I don't understand that how this is happening and who will be the buyer even in the auction or how
That is the purpose of
That is-
entire lecture. Na? The entire lecture was thought on this purpose only.
That is a problem. That is a problem because under 37, regulation 37 of the CRP regulations, as I was saying earlier, there are provisions. Because see, when the plan as a going concern, unless you set some contours, there is no, because in fact, earlier going concern, if you do the classical definition of going concern means that the company should or the business should be sustainable to meet its liabilities.
Yeah.
The revenue should meet its liabilities. That is going concern. Otherwise, it's liquidation. So if a company is under insolvency, how it can be going concern? Second is question which used to arise earlier, and now they have clarified in the regulations. Are you mandated under law to continue the same business? So, for example, there could be a company, and there have been instances where people have acquired a company only for the losses.
Yeah.
They don't want to run a business
Yes.
only for losses and then do a merger. So for loss, but if you're taking as a going concern, then what business will you run? So if it's a some defunct plant, manufacturing plant, steel plant, or whatever, so are you obligated to run the same business, or you can change? So that's why 37 was amended to say that you can change the portfolio of services and goods also as a going concern. The third is on the liability. So you because earlier in the initial when plans were being invited for monitor and all, people were wondering how will it work, because if you are doing a haircut, where is the provision coming from? That's why various regulations were again amended or clarified, saying that you can do a restructuring, security interest, you can have the same lenders continuing with a reduced this thing, higher maturity, like what you could do in a CDR, you can do under a plan. But with all those things are not there under sale as a going concern, because as you said, as you pointed out, there is no provision of a haircut, because if you are doing assets liabilities, then you have to 100% as per this thing.
Yeah.
So you cannot reduce the liability because you are not submitting a scheme.
Yeah.
So that's why you have to approach the NCLT. But NCLT also, if you see the reliefs, some write-off, write-backs, all those things they give, issuance of shares, formation of board, all those reliefs they give. But if you go into, and then people implement the way they want to and move ahead. But if you go into the nitty-gritties, and if somebody were to challenge, then somebody can very well say that if you're buying as a going concern, my liability is there. I am okay with not getting paid now. You pay me later, but you pay me the entire amount. That could also be a valid argument, and that is the reason why this entire thing, if you see the various committee reports also, that is exactly what they have said, that where do you put an end to it? Because plan is a well-defined mechanism with under the code and the regulations and the judicial precedents, that there is the end. But for liquidation, the going concern, the company is continuing. There is no plan, no scheme, no merger, no demerger. Company is continuing as is with assets and liabilities, and that is the confusion. Assets and liabilities. Then you take the assets with the liabilities. That is the problem which is happening.
So here, one thing that can be thought of probably, the challenge is the valuation. when you are looking at a valuation as a sale as a going concern, you should not be valuing it at the asset and liability base.
Only
It
asset
has to
based.
be a enterprise
Enterprise
basis valuation. So when you look at an enterprise valuation, it is not based on your asset value or liability value. So when the enterprise,
Business
now
value.
the challenge comes is when you are looking at an enterprise value, you get a fair value of an enterprise. But then there is nothing, no mechanism on the liquidation value of an enterprise. Because if if it is goes under liquidation, the enterprise, the valuation of the enterprise goes to zero. Then only the value under the asset will
Assets.
sustain. So,
So
this analogy-
enterprise you want to say is that pure asset only?
Sale as a going concern.
Sale as a going concern. I am only.
So liquidation process, regulation 35 clearly talks about the valuation. It doesn't say about the fair value and the liquidation, it says the realizable value. The valuation.
And it's,
you have to
and
divide
only do
Of
we
the
do
asset.
asset is only of asset, nothing of liability.
Liability, only assets.
So, and then once, otherwise it should be clearly that offer document should be clear that this is the asset only.
Yeah.
The offer
Maybe
document
I
should
will
be.
get two DC complaints only. DC orders which will come, which will settle these issues. Because all RPs and liquidators will think that
No, all.
DC, once it decides, then they know actually what needs to be done.
They know, but
Yes.
down the line, there may be a, vicious cycle of CARP, then liquidation undergoing,
Never
CARP,
This is
again, because it's with
buyers
liability.
came into play because of JP case. It went hue and cry, and because of JP, home buyers new creation came and started all the trouble. Now, Gujarat NRE Co, this new creation came, sale as a going concern.
And scheme.
So the issues which are of political influence, which will come, you will get new acronyms, new structures incoming, and we have to sail through them. It's like a hurdle race where we have to jump all the hurdles that come in our way. If caught, then DC will take action. If not caught, you sail through.
Yes.
So simple as that.
Now the biggest fear among all RP, whatever is now DC, and the way the DC orders are coming.
But I don't see to fear DC practically, because everyone has to be ready with a DC order. With command full stop orders, I don't think any RP will be outside the DC.
But now they have become more active, no?
Actually, we should suggest that 6 months suspension should be there of
Yeah.
process. Let them do all the DC order. Anyhow, 6 महीने का break दे दो, सब DC का ही attend कर लो.
नहीं, वो लेकर
मालूम पड़ा कि जो है उसको भी continue करो ना.
There are two already, if you know, 3 challenges against the DC order has gone and they have stayed the proceeding.
There
Two
are,
है, तीसरा किसका आ गया?
there are at least 15 challenges.
निपुण ने किया और एक
There are at least 15. If you go to the IBA website, the High Court orders, there are at least 15 challenges pending.
सुनील का उसका मालूम है.
15 challenges
1-5,
pending.
1-5, Mahindra Agarwal.
3 आएंगी.
Sorry, किसका?
15.
1-5.
There are about
Three are there.
there are 15 challenges, and that is going to become a thing. So now this recent one has come now, Sawan Godia wala, which is also going to be challenged. Yeah, yeah.
And
Enclave में जाएगा.
नहीं एनक्लेट में नहीं जा सकते हैं ना.
High Court.
High Court.
So DC in RRC, what we did, these were discussed at length, DC actions, to be very fair. So single member bench is issuing the order. Chairperson issuing the order. This is all outside.
So there is one Punjab and Haryana High Court judgment where they have stayed the order because this current chairperson was used to work with Punjab National Bank. So long time back, Punjab National Bank had filed a complaint against some RP. So nobody knew, nobody did the complaint, but after the order was passed, he realized that there's a bias because Punjab National Bank, so Punjab and Haryana High Court has stayed the order. Saying that there's a bias.
So basically, it's like you get a DC order and be ready to file a writ.
Yes,
Against the DC order and be ready. As such, now we all are accustomed to have one of our team member like Madhav with us to fight for us.
Yeah.
So we have to fight one battle, he will fight other battle.
Yes.
There is no alternative. But yes, as a sale as a going concern, it has a various challenges which are very peculiar. One of the challenge that I still foresee is this valuation, enterprise value. No one has come out with this because if it is a going concern sale, means it can be only done when the
Enterprise, yeah.
and business is bad. If there is no business, going concern sale should not be allowed. So when there is no business, then it is the ulterior motive to take it under going concern, to take some privilege of the various things which are not available under liquidation. And
How
that
to
means you are
close
stretching it beyond.
entity would have as a sale as a concern.
So that only where there is an enterprise value or a business value, and you are selling with the business and the asset together, where they cannot be separated, and the going concern sale is done.
But the enterprise value you are saying is a positive over and above the liabilities.
Sorry, yes.
Means enterprise value means you are saying the assets are of 100 crore and the liability are of 20 crore or 50 crore.
Enterprise value is based on the NPV value, future forecast of the business. That
Correct. But then after discounting the liability,
ECF.
after discounting the liabilities,
No.
He
Sir,
is saying asset liability-
enterprise value will be based on the discounted cash flow
Future
method.
cash flow.
Yeah,
correct.
cash
But
flow
then
liability.
present liability to be
Cash flow consists of liability payment as well.
yes.
So naturally it is included.
So it is net off.
Never.
Yeah.
So that enterprise value, so challenge will come because you cannot forecast only. In case of a company which is in liquidation, how can you forecast? How can you come out at an enterprise value? And how can you go with this value safe?
No, but then at enterprise value, it will be, let's say, after deducting the liabilities, then when the money is paid to the liquidator, he will further pay to the creditor under 53.
No. Once, yes, it has to be paid under.
Then how can it be double payment?
So that is where the valuation valuers are.
Suppose I have a liability of 100 and asset of 200. As a liquidator, I pay you 100 crore. So I take over that liability also 100 crore and pay you 100 crore, and that 100 crore you distribute.
No balance.
I am not giving. So when you do an enterprise value,
Scheme.
enterprise value is the value on the future cash flow of the company from the business.
Correct.
Okay. So business liability, whatever is there, can be factored into the cash flow and it can come to a current value.
Correct.
But when you are working on this, so that's what I'm saying, the challenge that we see in enterprise value, that this liability need not be factored because under 53 we are going to distribute. So the enterprise value needs to be, the valuer when you give this report, he has to be very clear that this is from the future business, the cash flow is being derived. Based on this is the value of the enterprise realizable value, which does not factor into the liability because if it is sold at this value, the money that is recovered will be used to pay all the creditors. If he factors it, then it will be a duplication of things.
Yes.
So that care has to be taken. So valuation is the whole, we all are talking on CRP, we all are talking on the liquidation, methodology of liquidation, but everything boils down to the valuation. And there is no one who is taking care of the valuation. Whether the valuation, when we are talking of dissenting creditor, it is again based on the valuation. Okay, but whether that value, what we are getting, what we are doing a valuation in CRP is land and building, plant and machinery and financial assets.
But sir,
where is the enterprise value?
No, the only thing is that you have a point because if assets liabilities have to move together, but that is the whole funda behind plan and liquidation both. Because if you see the definition, it's assets are sold at either a arm's length basis or a distressed sale basis, and what is realized, because that is because ultimately, see, we are under the insolvency mechanism. So your enterprise value. So, for example, in the ILFS sale of assets that is being contemplated, enterprise value, equity value, all those concepts are relevant there because there you may have a concept of continuing creditors. In insolvency, formal insolvency, once you take over, unless a person wants to continue with those creditors, there is no concept of continuing creditors and insolvency resolution. Under liquidation, legally, there cannot be any continuing creditors because that is what is the role of a liquidator? Liquidator has to collect the claims, form the liquidation estate, convert that into cash and distribute. That is the basic thing of the thing. Any mode of sale during liquidation is towards that purpose only.
But
So
maximization, the IBC core object,
no,
maximization
because enterprise value, then because that's what I was just thinking. If you take the enterprise value, then even for CIRP you have to take the enterprise value.
That is what I'm saying.
But that would mean that liabilities will continue.
Practically, what we are doing is an absurd exercise of taking asset value, whereas in liquidation, basically asset value is to be considered, but during CRP, because you are
Enterprise. As a going concern.
As a going concern in the CRP. So the realistic value is the enterprise value, not the asset value. And that's where the whole game lies. So there are other companies where there is no asset, but there is a huge valuation. For example, infra company, which has a base of 10 years. So if they have to go for a tendering, that company is empaneled vendor where there is a restriction barrier, a defense company, restriction barrier.
Correct.
Entry restrictions are there. Now that company may not have asset, but just because they qualify that and
The
that
bidder, yeah.
the barrier is there to enter, and there will be a buyer for it. Now, if you value it on the asset base, you will never get
Zero,
a value,
yeah.
realistic value. If you want to maximize, it is the enterprise value of that company that comes into it.
But has this been told to IBPI? Yeah.
Whether you can do?
Yes.
Get it done?
It is up to the RP. He has to guide the, I want a value of liquidation. Liquidation value, you have to take two values in CRP.
Fair value and.
Fair value and a liquidation value.
Correct.
You tell him I want a liquidation value. Don't tell that I want 100 crores. You tell him the methodology that you want him to apply. And additional he can give. So he can give me 10 values. In liquidation also, liquidation by stripping of asset, by slump sale, he can give, and each value will differ. So what is the model that I have to take? So I can take all the value from the valuers, put it to a stakeholder committee in liquidation, that these are the differential value coming in this is the most viable according to me. And that's why I'm proceeding this and militarize it and go ahead with the sale.
It's very difficult to value. Most CRP companies, there is operations, most different, there is no working capital, there is no operation. So how will you do
So
enterprise?
in the companies where there is a probability of revival, the companies where there is a probability of revival.
Sometimes again other challenges we find.
These are my views. These are my views. Just not sharing with you all.
Sometimes we find that the industrial land, but the land is very close to the city now. And we find that if it is converted from industrial land, it may have additional cost, but then the realization will be much more.
Construction.
Yeah.
Change the
User. But then liquidator will not do that. Somebody as a buyer will have to do. I don't have the money also, I don't have the need also.
So at what value you will get it?
Yes.
Sir, आप caretaker हो.
Caretaker.
Caretaker का वो समझ के करना है. आप enterprise entrepreneur नहीं
हो.
वो सोचना ही नहीं है आप.
सोचना ही नहीं.
आप trustee हो. Trustee के हिसाब से काम करो. I always take in my lectures, I share this, that we are atma of the process. Spirituality में कैसा रहता है, body के अंदर जाने का, और time is over, you leave the body. 180 days का time है, enter that, do your karma, what is written in the code, like you would other to the DC and move out.
One more thing.
Finish.
Like listed company is there, if it is in CRB, it's okay. If once the liquidation order passes, whether it will be automatically delisted or how? So you have to go and apply and all those things.
You have to apply.
You have to do all the formalities. So then he is saying thousands of
which you have to fight, and that is the reason why most liquidators do not take that headache. They do the compliances, whatever ongoing compliances, and once the dissolution is done, that is when they ask the NCA. Yeah.
But otherwise,
the problem will arise only, and as far as SEBI is concerned, so this is also faced in plans where there are a lot of non-compliances. So we face a situation where company secretary had not been appointed.
Yes.
It was a daily offense. So nobody looked at it, and the reason was no company secretary wanted to come to that company. So the fine came to around 35-40 lakhs, and it was CRP cost. So everybody was like, how can RP incur this kind of CRP cost? Then RP and the RA and like through with the lawyer support, they approached SEBI and the exchanges that this is the reason the company is under CRP, and SEBI exempted.
But most of the time, BSE and other exchanges, they are not listening to the RP, saying, okay, this is how their law, they will apply this fine.
See,
it's
about time. It's about timing. So what happens is, one is a continuing offense. So you are supposed to make some quarterly, monthly filings, MIS filings, and all those things with the exchanges. Promoters may not have done it prior to CRB commencement. As an RP, like that is how we advise the RPs for listed companies nowadays, that first thing apart from claim collation, first thing should be to look at these non-compliances, get a handle of these non-compliances, and immediately apply to SEBI and exchanges. Because what will happen is, if you do it after 6 months, the cost which has been prior to this thing will keep on multiplying.
So now if you apply this, they are saying 5,000 rupees per day penalty is going on and it is going on. So they can't reduce it or something.
You will get an exemption. So what?
And they have not filed the claim also.
No, the golden. So that is the thing. So that is the reason why RPs for listed companies have to be slightly more proactive, given the past experiences. Is that the insolvency commencement date is like the Lakshman Rekha. Before that, it is claim. SEBI, NSE, BSE, everything is a claim. Post that, because under 23 you have to comply with applicable law, so it becomes your liability as CRP cost. Now it will be counted into
CRP cost. There is an amendment that has come, and this is a headache for us.
Penalty is
Now it
considered
is
as
not a CRP
CRP
cost.
cost.
Any fine on this thing.
Correct.
It is RP's cost.
RP's cost. Now it's the RP's cost. It is.
RP cost will be
No.
It is not a CRP cost.
It is not CRP cost.
Whose cost they have not defined.
Yeah. No. I this thing, but I'm talking about the previous this thing where they were saying it as a CRP because it arose in CRP period, so CRP cost, and people used to apply, and what SEBI used to say is that, why are you coming at this stage of implementation when the process is going for 2 years? Why didn't you come earlier? Because now for them also to give an exemption for 5 lakhs is easier than to give an exemption of 50 lakhs. And in every case, if they give so it's all notional, like on paper amounts, but they have to give the exemption. So that is the reason why nowadays RPs what to do is they, through, like, if Big Four is involved, and through them, or appoint some specialized person, look at for 10-15 days, do an audit, what are the non-compliances from a listing perspective, and just apply to SEBI that these are the non-compliances. I have done this, I have taken charge.
For the
CRP
value,
of
which is
Paisan
going to
is
get,
For the-
COC is not allowing even a
Even a
professional
single
to be
rupee.
appointed.
Hmm.
These are the issues.
No.
Burning issues.
No, but
You're just touching our nerves, which are having a
No,
burning
no.
issue, which we face.
But for this, see, the thing is ki COC, and it comes, like, for example, in one case you are facing where NSE, BSE, so quarterly filings, shareholding pattern, promoter group holding, everything has a different fine, 1,000 rupees, 2,000 rupees, 5,000 rupees per day. They were not, and the system is like how GST used to be. If you have not done a previous filing, you cannot do a current filing. So that is another problem.
Their amendment is coming.
So that amendment.
GST you have to number. GST it is.
GST has come for exchanges, it hasn't come. So when you try, so some RPs go and try. Exchange says कि no, you do all the non-compliance and everything, and RPs then say कि plan में होगा, देखा जाएगा, वो देख लेंगे.
But what's about under companies that, for example, a company which is not listed, it is delisted company, limited company, continues only one director on the record.
So how can we?
Which is from pre मतलब CRP.
So
continued since 2014.
They have not filed
That is a simpler battle to fight, because simple thing is ki whatever is the past non-compliances,
You file claim.
the claim or whatever, it is extinguished, and whatever is during this period, you have a justification that board of directors, technically you need to have 2. You can appoint
Three,
another public limited company 3, but you don't need to.
You are saying board of directors meeting should be happen. Board of is suspended board. No board meetings are happening. And stock exchange is saying your board meeting minutes are not filed. Your fine is there.
Yeah.
So how to do it? Now they are saying already plan has been submitted to the NCLT. Now they are saying AGM is not conducted. AGM why we are not conducting? Why you are not calling the?
That is what I'm saying. That is from the collective learning. That is the thing, because this listed companies, this audit has to be done expeditiously, and this has to be brought to the, because see why this is important is, if in the first month or 45 days you are able to pin down these non-compliances, and which will continue, because for an insolvent company it will be difficult, and we have phases to appoint directors. Nobody will come as a director.
No one will.
No director, no company secretary is coming.
Yeah, company secretary, you will find it difficult. So you have to tell the exchanges and SEBI that this is a problem, and that's it. If they continue to apply the fine, then you have a very clear case of going to NCLT and getting it quashed. So that is the thing, because see, the thing is that fine will still be there. Now it is not CRP covered, fine is still going to be there. No, RA also will find it difficult because RA cannot extinguish that fine which is in that CRP period. Pre-CRP he can extinguish. Post.
Can we ask the RA that there is so much amount of fine which is not a part of CRP cost, but we will have to bear it?
No RA will bear it.
No, and if a bears and pay lesser amount to the financial creditor will not accept.
Yeah.
Say why say that your value is 100 crores.
If it will be compounding, so no RA will bear it. And that is so. It ultimately it will come out from the lender's kitty, and if it comes from the lender's kitty, the RP will get so that's RP will get blacklisted. So the best thing to do from an RP perspective is to do that thing, audit, get the non-compliances in place, write to SEBI and say this is not possible. This is a non-compliance. I'm an RP. Please, like how we do for factory occupier. Earlier it was the factory occupier. Earlier it was difficult because under the Factories Act, a director has to be an occupier. There are instances where all directors resign. Now if they resign, you cannot force them to continue. An occupier is an important thing because a factory, if something happens, he is the person who is liable. So in some cases we have seen directors having appointed from the employees, which is a cleaner way to do it. And if you are lucky to have employees who are willing to become directors, other is that some employee without making him director, because people are willing to become factory occupier because they are set this thing but not become director. So
leads to one more question from myself, maybe out of syllabus. But as a RP, does the RP become an occupier, factory occupier? Because the board is suspended during that period. So does he become a factory occupier?
That's what I was saying.
Director's responsibility continues.
No. If directors resign,
I have resigned. In one of the cases, director have already filed that they have resigned.
Yes.
In all cases,
without the knowledge of RP. Now, when he is gone, how he can resign? So he's saying, I've done it.
So there is a case. In fact, there are two cases. One is of AMW Auto Component, NCLT Ahmedabad, where so we were there for the RP. We were as RP counsel, and that is what we said, that some employee who had resigned as director, but he was the occupier. So we went to NCLT because what the Labor Department was saying is that RP has to become the occupier. Because RP is now become the board, it says person who is ultimately in control. So RP has to become occupier. Now no RP will become an occupier, especially when an RP is based in a city area, factory is in somewhere in the interiors, because occupier technically should be close to the factory. So it is impossible. So what we did was that we went to NCLT, we took them through the scheme of the code, and these judgments also that director's responsibility continue. But the question was there are no directors, and we said that there are no directors, they have resigned. We are not able to appoint directors because COC will not, because COC approval is required. COC will not give approval, and nobody wants to become a director. So what they and Labor Department said that we cannot accept anybody else as an occupier because the code says, the act says a director has to be an occupier. So with all these things, the NCLT took a reasonable stance, and they said that okay, RP is anyways in charge of the ultimate in charge of all the affairs, because RP has to comply with all the laws. This is RP's responsibility to appoint an occupier, a qualified person. So let the RP appoint the occupier. In other cases, we appointed directors also. We have done because directors mil gaya to wo best hai. We appointed director. We appointed.
The company secretary, I went to company's institute, and I have taken. They have given me a list of person to whom you can
approach.
25 persons I have identified. I have given offer. Okay, 25 persons anyone can join. No one has joined.
No one joined.
Because it's a.
जैसे बोला CRP में, what is the CRP? Okay, insolvency में. No.
Officer becomes an officer.
So on this list, if it is a suspended shares, what happens?
It becomes part of CRP cost. उसको तो करना चाहिए. CRP cost मिल जाएगा.
The Factories Act,
it remains suspended.
The director has to be an occupier. What it says is the person who has the control over the affairs of the company.
No, but there are cases which says director. In the case of a company, a director has to be occupier. That's a
that is
Supreme.
Wrong, because even I'm studying Factories Act now.
Supreme Court
you
case.
You are already a LLP. I am pursuing LLP.
Supreme Court case hai where JK Synthetics.
You were there in in these, this thing, categorically we discussed that, it is not mentioned in the Factories Act, forget about the order.
Acha, just a minute. For the benefit of those who have joined online, let us give them some time for questioning.
Yes.
So those who are online may question if they want to ask any question.
Also, with regard to compliances, the company which is closed from last 3-4 years, no compliances, everything is seized, and stock exchange every month sends that information. This is non-compliant. This is non-compliant. We reply to them. We can't do it. Then also they send it. Now, suppose this is the plan
identify yourself.
comes in and afterwards.
सबका नाम सबको मैं जानता हूँ.
So afterwards, what they say, now we understand the law. During this CRP, everything has to be paid because we are not asking for the pre-CRP, at least for the CRP period, you say. We said, sir, you can suspend it, the script. We are not able to comply. Still, they are not doing it. How do we, handle it? Because now the Snail Bhai just said, now it's become a liability of the RP. Now everything will come on us. So how do we encounter writing and everything is okay?
So for that, as I said, now with this new, like the
one more thing to say, including Inc. 28, the ROC is saying we will not take in a record. You file first the annual accounts, then only will take in a record. Now,
no, so for the SEBI related thing, the most important thing is to bring it to SEBI's attention and exchange attention at the earliest possible opportunity, because now those days are gone when RPs used to run the company for a year, 18 months, then no other non-compliances when a notice used to come, and then say, oh, it's CIRP, because then nobody will take the RP seriously. So there have been exemptions. Like there are several cases where SEBI has taken a lenient view and said, okay, you don't pay because of ABC reasons. You are handicapped, so you could not appoint a company secretary, you could not appoint director, you could not hold board meetings. So SEBI takes a view, but that is at the discretion of SEBI. So the best thing to do is bring it to SEBI attention. If they still continue to apply the fine or impose the fine, approach NCLT. That is what people are doing. NCLT will, because SEBI is one regulator which actually they are challenging orders, but they are actually giving some credence to NCLT's orders. No other regulator is taking it very seriously. But SEBI is one regulator who is routinely taking it seriously. That is one. As far as ROC is concerned, ROC is a very simple this thing. There are, I think, some orders also of NCLT Mumbai where you just approach the NCLT immediately if they are not taking any form. If it is part of a plan, then anyways there is nothing to be done, because ROC to write a letter, a threatening letter saying that this is as part of the plan. If you're not taking it, then too bad for you. We'll go to NCLT and they will immediately do it. If it's doing the CIRP, then just go approach NCLT. You will get an order immediately. Immediately meaning without any fuss. Immediately meaning 90 days or something.
It doesn't happen actually. I tell you, in one of my case, where the stock exchanges, initial 3 months, 4 months, they have not taken a record. Even they have scanned through all the resolution plan. Yes. They say we will not do it. All the action items like reduction of capital, relisting of the scripts and everything. Till today also in that company, the opening balance is showing, though they have complied afterwards with this thing, but the opening balance is still showing. They are not enforcing for payment, but they are allowing it to happen.
Which year the plan was? Sorry? Which year the plan?
2019. Approved in 2021.
Now it is.
Okay. Because I agree, because in 18-19, this problem was there where people used to say within 30 days or 60 days we'll implement. And it used to take 6 months because exchanges were understanding what is happening and delisting how it will work and all those things. But recently in 2021, we saw a plan where within 10 days they gave the approvals. Cancellation, reduction, listing and trading. Within 10 days, everything was done.
So NSE is open.
Matters admitted within 7 days.
No, SEBI.
No, that's what I'm saying. In NCLT, within 7 days, matters are admitted. And there are matters
5 years.
since last 4 years.
So NSE is open a portal.
7 days it is admitted.
Online waiver. But what they say
is plan.
Karaikal Port 7 days admission.
7 days.
Monday filed, Friday admitted.
Good. Prashant, continue.
Yeah. So, sir, NSE has opened a portal which allows online, application for waiver. But what they say that whichever is your first, exchange. Normally, the old company is having a BSC as a first exchange. So first they will do it, then we will do it. Along with this, there is the issue of RTA as well as the NSDL CDs. NSDL CDs, they don't break it. Though even stock exchange is still they we allow it. But NSDL CDs still they don't do it because without their unlocking, you will not able to download the Bankruptcy. So it's a vicious circle. If one you allow it or you convince, the other one will go in a different direction. So it's very difficult. Still by what you said, now it's become RP cost. So it has to be now, all we have to represent to the
SEBI,
regulator. SEBI will not do anything. SEBI will not do anything in this. Our regulator has to understand this.
Yeah, no, but regulator has to approach SEBI because SEBI actually is because we have seen from experience, SEBI in the initial days when delisting and all these regulations were not there.
The chairman of IPPI was an ex-SEBI.
Yeah, he's.
Now you will see the difference. Okay, so now you will see, now income tax will become friendly because the old-time member from income tax has joined there. So now you will see income tax becoming friendly and SEBI going on the other mode. It's how the regulators interact.
Could be.
So this is my interpretation.
Soniji wanted to ask something. Soni karke aaya.
Yes.
Any other questions from the online participants?
Yes, sir. You already put forward my question.
Yes, sir.
Sorry to ask a question at the fag end, but the very fact is that the going concern has never been defined under either the act or anywhere else. So, what is your views on it, especially the legal views?
Sir, so income tax and even for Companies Act, some say, and even in the IBC, there are some judgments now of NCLT where they discuss going concern. So at least when we advise on plans and all, and I was saying that how you can change the business also legally, going concern is something which is a self-sustaining business in the sense that the assets and the revenues are enough to meet the liabilities. That is a going concern very fundamentally. So any self-sustaining business, if you are able to define or identify, is a going concern. So that is what we normally take. Like obviously you guys are the experts on the accounting side, but when we do slum sale, BT, business transfer agreements, or any demerger or anything, when we take a going concern undertaking, so it is normally defined as a self-sustaining business, at least to be able to justify that the business will be sustaining itself. Otherwise, it will be liquidation. So that is what the going concern thing is, and that is the problem why it is not defined, and what we discussed earlier, assets and liabilities, because that is the classical accounting definition, that going concern means assets and liabilities move together. That is a legal principle also. But in the context of a liquidation or insolvency, if assets and liabilities move together for going concern, it may defeat the purpose of the code. So that is the entire problem. But I don't think so. We had at least I remember in 3 years back there was some discussion with IBBI in some forum where Mr. Sahu was there, and somebody asked also that why don't you define going concern, because it is creating problem even for plans. He said that going concern is something which can never be defined by anybody, and if you try to define it, it will lead to more litigations than solution. So it is best left to the imagination of persons who are implementing the scheme at that point in time for going concern.
So the reason I have specifically asked this question,
there is no solution, RP is the only solution.
Yeah.
There's a reason I have specifically asked a question. There have been orders which have been passed wherein a company which has not been operating. I mean, not operating is a company which is still in the process of, loans are being given and a project has been formed and project is under process of being implementation. It has gone into CRB and then it has gone into liquidation. The stand taken, or normal stand taken, or what as I understand is that the company has to be running.
But we don't specify key work on this. Like there are practice areas.
Yeah, Soni.
Nandan
Soni ji, mute कीजिए ना.
Yes, कह रहा हूँ.
So a going concern means there has to be some operations in the business to be formed as a going concern. As you rightly said, there has to be something going on. But a project which was supposed to be started has not started, and there is no going concern. So if there is no going
The
concern,
control
it
control
will
is
allow
there.
to be.
नहीं वो देख कर रहा है
ऐसे म्यूट कर सकते हो तो कर
इधर से म्यूट कर सकते हैं
that changes can be
उधर
made.
से देखा होगा
Soni ji,
सोनी जी
Soni ji, kindly mute yourself.
Let's say in dash team.
कौन है
Legal training or
हाँ, वही इसका नाम
legal training or legal intern. हाँ
है क्या उधर
हाँ that was your that.
भाई WRC के कोई है क्या एडमिन प्लीज म्यूट सोनी जी चलो
नहीं हुआ
नेक्स्ट टाइम कंट्रोल इधर रहना पड़ेगा
आज छुट्टी कर
लेना पड़ेगा ना अपने
इसके बाद
WRC के पास
हम लोग कोई आज कर रहे हो कल दे रहे हैं सर
अरे सोनी जी
सब रिकॉर्ड हो रहा है सर, आप बोल रहे हो
एनसीएलटी में चले जाएगा
और बैंक में तो कल थे
इसी के पास जाएंगे।
हाँ?
इसी के पास जाएंगे।
अच्छा गहलोत जी यू कैन कंटिन्यू प्लीज कह रहा भाई आप बोलो
What my request is that, as is rightly said, a going concern is something which is running. But a project wherein the project has not been implemented, it has gone into CRP, and then the process has been completed. Then there is no question of going concern. Whereas the orders have been passed, wherein, yes, sir, wherein orders have been passed of wherein reference has been given to V. Shivrama Prasad versus Dhanpal and others, which is Company Appeal 224/2018 of NCLT Delhi. And this order clearly states that, in liquidation, there are two stages. First stage is you give one more opportunity to the person or the city to continue the CRP process. This is the first stage. And second is the sale of assets. In the first stage, there has to be something going now, sir. There is, and going concern means it has to be sold along with the employees, along with the creditors. That is what I presume. If I'm wrong, you can just guide me in my.
No sir, so there are two aspects to it. One is going concern. There are numerous examples of defunct companies or holding companies which have no operations or anything. They only have shareholding which have gone into insolvency. So the classical definition of going concern may not apply to them, and that's why coming back, the valuation is based on assets and not on assets and liabilities or going concern valuation. That is the reason. But as you said, going concern legally should transfer along with assets and liabilities. But if that happens, then it will defeat the objective of insolvency resolution. Because if you transfer liabilities or creditors or any kind of liabilities, encumbrances, then nobody will find a resolution. So that is the reason why both the liquidation and resolution, you transfer the assets, you realize the money, you distribute, and then you settle the liability, extinguish the liability. So that is the thing in insolvency. Now going concern, I think like one other way to look at it is now it has come to this thing. Going concern could be that if you are resolving the company as a going concern, it's not based on past this thing. Going forward, you have to do a business which is sustainable, because that is a going concern. So you should have as many liabilities and as much assets or liabilities which are able to be supported by the assets and the operations. But that is something, again, there has been no detailed judgment on going concern, and there are references like what you said, Dhanpal Prasad. There is in Top Earth, in a couple of other cases also they have defined what is going concern, this thing, but they have not actually gone in behind the actual legal definition. They have read in the IBBI discussion about 2018 or 2019 where we discussed that going concern assets liabilities, but that is about it.
Accounting standard what agreement is a more
Yeah.
in my opinion. You have to continue the same scale of
partnership agreement.
any question from anyone else?
size of the operation.
No.
Anyone?
Company is working at 10-20%, then you will
will
continue
close
to
the
operate at
proceedings.
20%. You will not reduce below 20%.
Yeah.
So that is defined in accounting standard one.
Ganesh.
But that is not applicable to IBC. That's the thing.
Ganesh,
Because there you can reduce from 20 to 2% also. So if you take that,
Yeah.
IBC तो only electricity payment हो रहा है, light का payment हो रहा है, internet का payment हो रहा है. People continue that.
Yeah, Ganesh ji.
Good evening. Thank you. I just thought, sorry, at that time I didn't want to disturb. The ending of Amit Metallics, it's a 21 judgment. Should that be the reference point, or we are, because there's a lot of contradiction according to you as far as that Amit Metallics judgment? Because going forward, should it be used or should it not be used in interpretation?
Sir, so the basic thing is that unless a larger bench such as JP Kensington and SR Steel, Amit Metallics, so legally speaking, it is you can't say per incurium. It is because they have actually referred to the judgments, but it is not the correct position what people are trying to interpret. And as I said earlier, Amit Metallics is in the corner of 30 subsection 4. So because Amit Metallics does not say that 30 subsection 2b is wrong, in the sense that dissenting creditors can be paid less than the liquidation value. It does not say that. So the law, as per the statute and as per the other judgment also, but you have to anyways go to the statute. Statute is very clear that dissenting creditor has to be paid as per the the liquidation value. That is one. Second thing is on JP Kensington also, as I was saying earlier, says that you can allow the dissenting creditor to enforce the security. So the presumption is when you are computing liquidation value of a so normally what we apply, and it was discussed in JP only, JP Infratech COC only, what is normally applied as a good principle is that when you are computing a liquidation value of a creditor, you assume that he will enforce the security. Whatever the security he has, he will enforce. So that's why he will come. You will take the value of that security plus he will come later in the pecking order. So that is how it is computed normally, and not by relinquishment and pooling. So you have to, as a matter of law, you have to give respect and honor to the security, priority, and value. That is the basic principle. But Amit Metallics and this Technology Board of India, they have confused the waters. Hopefully, Supreme Court will set the
because HDFC Bank case, clearly they were losing and they tried to fight that battle, but eventually they lost the battle. That's what I understood, Amit Metallics.
Which one?
HDFC Bank, in this case.
No, this was this one. No, Amit Metallics was this ARC.
No. Thereafter, it went. I think HDFC Bank was the sufferer, wherein they were getting less. They had, just as you rightly said, they had a property or some value, and that property they would have got higher value.
India Resurgence.
But because they were in CR,
India Resurgence Fund.
India Resurgence Fund, yeah. I think that's what. So, nevertheless, I think that's confusion remains. Looks like.
Yeah, it remains. But if you take any opinion, say from any lawyer or law firm or judge, and I can say that like we have seen opinions in certain COCs where external opinions have been taken, because say we are a COC counsel, so RP will not take his counsel's opinion, but an expert like independent opinions because of discussions. Everybody will say that Amit Metallics does not change the basic position that you have to pay as per the security interest, you have to pay the liquidation value. Because what people are trying to use Amit Metallics to say is that you can go below liquidation value even for dissenting creditors. That is not the correct position unless the law is amended.
Thank you.
Okay.
Any other question? Last question.
Just one last question. Can 230 be read with IBC when it comes to implementation? Can we say that 230 is not standalone? It has to be read with IBC. Maximization of value is very important.
230.
230. See, normally orders are given. The earlier orders which I have referred to refers to section 230. But 230 has to be read with IBC. It is not standalone. IBC is maximization of value or revival of the business. Whatever the objects of IBC are. Maximization of value,
correct.
Revival of the business.
So 230 is a complete code by itself. It is legally it is independent of IBC. When applied under IBC, so 230
under IBC, can we take
yeah, you have to, because 230 also, see, ultimately 230 also the way it came about is that the company should not die. With 230 you can have a going concern revival. Again, we come back to the same thing, going concern revival.
Precisely.
That's why you have, so all the object of IBC will have to be followed here.
No, just one last thing. That means if an order or a particular thing has been passed, wherein the a resolution process which is done under the first going concern under liquidation, if that mentions that the company has to be dissolved, then where is the question of going concern? Within
company
the
and
first
business are
90
two
days, when
separate
a
things.
liquidation has been done, under 230 read with IBC, and it clearly, the resolution, the person who is taking over clearly mentions that the entire the committee which is formed, which includes stakeholders committee also, approves the plan which involves dissolution. So where is the question of continue? Yes, which is approved as a dissolution. So where is the question of continuation of business?
So sir, 230, the objective is to see, we have to also understand, as I said earlier, going concern during liquidation, winding up, bankruptcy is primarily to save the workers. That is the main thing.
Yes, workers are not continued. Exactly, precisely. That's what my question is. Workers are not continued. OC is not continued.
So then this 230, what you are referring to, is merely a merger, demerger, and then distribution. So it is not like a revival of the business. Somebody just wants to take advantage of the asset and the losses. So basically get an undertaking and then let the company dissolve, which is also permissible.
But then it is against the objects of IBC. It is against the objects of this very case laws also, which clearly says that
no, sir.
Dissolution is the last resort.
Liquidation is the last resort, not resolution.
So, sir, objective of the IBC is to maximize the value of the asset of the corporate debtor. One of the objectives of the IBC.
Yes, yes.
So, if by way of a 230 scheme, you are getting 100 rupees, and in a piecemeal sale you are 90 rupees, so 100 rupees is fine. But that's a. But it doesn't mean that
if it is the other way around, if you are not getting, sorry, I'm asking a lot of questions.
Yeah.
No, order has passed. It has been challenged.
Then it should only pass.
With due respect.
I think we conclude now.
Yeah.
With this, we conclude today's meeting.
वो recording अगर वो बंद होता है तो कर दो.
नहीं होगा. उसको.
नहीं हम लोग सुनेंगे ना उसमें क्या प्रॉब्लम होगा सर.
Okay, fine. Kero bhai.
Thanks.
Thank you for your active participation.
Thank you, sir. Thanks for the comments.
And I request Atul ji to propose RTH. Yeah. RTH vote of thanks to this today's leader.
I, on behalf of WRC, would like to thank Madhav for taking this interesting topic on liquidation. As a going sale as a going concern. Still, I have got my doubts because there are many things not yet clear. And he was kind enough to take other queries also in the related, because there is no deadline, no line. So we have raised other queries also. So anyway, as the times involved and new judgments come, so I think there will be more clarity. Thank you for explaining your time.
There will be new regulations also or code also. Yeah. Amendment.
Thank you, everyone.
Fine, friend. You
Thank
can
you, sir. Thanks a lot.
Thank you. Thanks. Next meeting, as there are a lot of DC orders, so we request members to come forward and take, or one or two members can come forward and.
We can
Snehal bhai.
We'll put in the group.
Snehal bhai.
Meeting ले लो. DC
पे ले लो.
Discuss करके let RP know कि भाई क्या what he has to follow and what he has to.
What precautions? What precautions should be taken?
स्टडी करना वेस्ट ऑफ टाइम है, वो कॉमा फुल स्टॉप निकाल रहा है, और ये प्रोफेशन में कॉमा फुल स्टॉप पे काम ही नहीं कर सकते हो आप.
कर ही नहीं सकते.
हाँ.
उसको बेस ही नहीं समझ में आ रहा है कि क्या बेस है. What is this? What you are asking RP to do that work? It's like basically doing an open heart surgery without knowledge of what is open heart surgery. ये वो डीसी ऑर्डर ऐसे निकालता है.
वो बोलता है कि they want
ऑर्डर पर
plans for group representation भी करता है insolvency. With a resolution of that company.
नहीं स्नेहल भाई.
It will be Snehal bhai. It will be like horror movie show for IPs.
स्नेहल भाई ले लो ना नेक्स्ट, और कोई पार्टनर के साथ ले लो. 3-4 ऑर्डर.
सर ऑर्डर लेने का कोई इशू नहीं है, बट एनालिसिस ऑफ दैट ऑर्डर उसने इतना पोस्टमार्टम किया है ना कि उसने आपको कुछ करने जैसा बचा ही नहीं.
करने के एटलीस्ट बट लर्निंग तो हो जाएगा ना कि व्हाट वी शुड नॉट डू.
नहीं कुछ भी करो.
I challenge you, sir.
आप कुछ भी करो,
ऑर्डर निकल के रहने वाला है।
अब उसने COC में नहीं दिया because ये not suspense नहीं दिया, तो केस लो है, you can't be a part of you, I can't admit if you don't give COC expenses, then do the DC order first. हाँ, ऊपर है कि DC है।
अरे NCLT ने बोला कि you should if the COC is not paying you the money,
you don't have to disclaim.
Take away
But not in that particular.
voting right to ले लिया order अरे क्या order है उसमें?
तो मैं क्या
In the same case, in the same case.
No, some other case.
Some other case.
But they are saying that when the court doesn't give you that power,
How can you do
how can you do
But
that?
that-
That order is reference to a specific case. So you don't have a power to use that order in your own case.
But that is the, as in, it's not the, I'm not saying DC is correct, but a basic principle of tribunal versus court is, so courts are court of record. Court of record means that when a court passes an order, it becomes a precedent, judicial precedent. Tribunals, the theory is, tribunals are not even bound by their own orders. Forget any other tribunal being bound. So yeah, so it is a case specific thing. So that is the reason why nobody has taken this, but that is the reason. But
I get an issue whenever I represent NCLT. I don't accept the claim after 90 days.
but there are a
And
number
the
of
bench
judgments.
always says, why are you so many judicial pronouns? I have to say that, sir, it is case specific.
Regulation.
I have not accepted, but I have said that if
No,
your
actually,
lordship is
now
allowing
there
me,
are
I
a
am
lot
ready
of
to
DC orders on this matter, 90 days ke baad you are
How-
not supposed
yeah.
to, because the code actually regulation doesn't allow it.
And there
We
are,
haven't taken a stand unless we
And it
directed
is
you,
all
you give
tribunal
direction
orders
from
only.
NCLT.
and you are right, because RP is at the middle of both the things, because
Yeah.
DC will say, why did you admit? And we have seen before NCLT where they say, why are you not admitting and wasting the court's time?
The first judgment where the RP has got a permanent suspension, Martin Gola case, is a fight between the NCLT and
IBBI.
regulator.
Yeah. On that
Palika वगैरह IP बना.
The IBBI
Settlement.
went ahead in filing NCLT
Settlement, that's settlement case, no?
Whatever the study and prove about. He told RP to file. RP said, boss, what I filed, I have done mistake. I filed that to NCLT. So he said, if you don't file, we'll take action. And the action was taken, was he is permanently suspended.
Matter क्या था?
Settlement, some settlement.
Means के केस में था issue था वो सब.
जब तक आएगा तब तक
देखो RP ने काम गलत किया, सही किया, वो secondary. The point that is that it was a fight between judiciary and IBBI where the IP became a state.
सर अभी तो सीओसी का अप्रूव किया हुआ एक्सपेंस भी डीसी बोल रहा है कि यू कांट डू इट इवन दो सीओसी अप्रूव्ड इट यू आर नॉट ऑथराइज्ड टू डू इट अभी राकेश शर्मा का एक ऑर्डर आया था मिस राकेश शर्मा देयर इज नो व्हाट यू कॉल एनी पेनल्टी ऑन लीनियंट छोड़ दिया लेकिन ये दिखा
There is no consistency.
Rekha madam, you
suspension दिया, किसी को 6 महीने का दिया, same fight, same issues, but किसी को 6 महीने और किसी को spot free किया.
15 days लो ना,
एक
महीना लो.
अभी तो अगस्त
In one of the
सितंबर
case,
में
one
ना
of the lady advocate had presented the same issues in other case. The RP has been fined and here he has been given a spot free. And against that RP 3 times the issue has come up. And all the 3 times he was got scot free. And if you read that judgments, the issues that are raised, and you see the issues that are raised with other RPs, where the fines or penalties or suspension is given, they are same.
100%.
So there is no consistency in judgment also.
कौन सी लेडी एडवोकेट है हम नाम रख रहे हैं तो हम भी देख लें.
आएगा तो बोल देना, मैं नाम दे दूंगा मिल ले.
So I think anyhow we end this meeting. Thank you very much everyone
Thank you.
for your active participation. Thank you.
Thanks everyone.
ये तो प्रशांत है.
वो जो रिक्वेस्ट का इशू था अशोक कृपलानी yes not allowed the creditors to participate not paying, so as per this judgment I can tell now kind of given the judgment also as per this judgment I will not allow you to participate.
And then he has spent,
DCA लगा दिया.
he has spent some 5,000 rupees on ticket of his son along with the visit.
He is a senior citizen. वो बेचारा जो बाहर में है, तो he was not well, so he said कि भाई ठीक है मेरा son जाएगा. He was also adopted. तो बोला कि वो मेरा son के नाम से ticket दे दो. It is a non-part, मतलब we cannot order on this.
All daily ticket to here is minimum to be. Tomorrow if they catch me, I have to tell that she is 100% participating in the entire process, not only a ticket.
Correct.
Each and every meeting, each and every aspect. she is
RP or non-compliant,
चलो friends.
Chalo.
Thank you very much.
Thanks.
अरे आ रहे बहुत फोन आ रहे हैं, क्या करें?